of the Holocaust. We have been saying never again. But unfortunately, Putin and his accomplice Lukashenko, with the help of Russian troops and silent or not so silent approval of the Russian citizens, are making us relive the darkest pages of European and world history, less than a century after Hitler's and Stalin's war. To ensure that never again are not just empty words, we need to react firmly and consistently. We want to believe that we live in a civilized world that rests on respect for human rights and not on brutal force. However, in reality we see that all the declarations and treaties do not stop dictators from committing war crimes and crimes against humanity at our doorstep in a democratic European country. Unless all perpetrators and everyone who is complicit receive their sentence and just punishment,
teisingumo, tada tarptautinė viešoji tvarka neteks prasmės. Lietuva yra viena pirmoji šalių, kuri perdavė karo nusikaltimus ir Rusijos įvykdytą nusikalstamą veiksmus, perduoti nagrinėti tarptautiniam baudžiamajam teismui. Visos šalys visame pasaulyje prisidėjo prie Lietuvos pastangų. Šiandien Lietuva su Lenkija ir Ukraina yra pradėjusi savo pačių baudžiamosios tyrimus, tirdama agresijos nusikaltimo ir karo nusikaltimų tyrimus Ukrainos žemė. Tam, kad tarptautinės ir nacionalinės pastangos užtikrintų teisingumą, yra labai svarbu koordinuotai rinkti šių nusikaltimų įrodymus drauge su mūsų tarptautiniais partneriais. Negalima leisti, kad klestėti nebaudžiamumui. Visos šalys atsakingos už tarptautinių įsipareigojimų įvykdymą. Konkrečiai yra įsipareigojusios nubausti tuos, kurie yra atsakingi už tarptautinių nusikaltimų įvykdymą. Jeigu neturime veiksmingo mechanizmo, leidžiančio užtikrinti teisingumą, turime sukurti naują mechanizmą. Ukrainiečių drąsa ir ryžtas gyventi taikioje šalyje ir ginti savo laisvę nuo agresorių, tai yra pavyzdys, ką gali padėti pasiekti toksai ryžtas. Lietuva nesustos ir toliau rems ukrainiečių pastangas, stengdamas užtikrinti ir padėti ukrainiečiams susigrąžinti savo laisvę. Ši konferencija yra vienas žingsnis šią linkme. Kaip jau ir minėjau, mes esame kryžkelėje. Manau, kad mes galime pasirinkti tinkamą kelią ir sustiprinti, o nesusilpninti pasaulinę tvarką pagrįstą įstatymo viršenybę. Šiandien turime ne tik žodžiais, bet ir darbais įrodyti, kad mes esame teisingoje pusėje, žmoniškumo, humanizmo, žmogaus teisių ir teisės viršenybės pusėje.
That was our Prime Minister, Ingrida Šimonytė.
Klausėmės premjerės Ingridos Šimonytės, o dabar norėčiau suteikti žodį teisingumo ministrei Evelinai Dobrovolskai. Tarkite. Labas rytas. Pirmiausia, esu be galo pagerbta, turėdama galimybę organizuoti šią konferenciją Vilniuje. Garbus konferencijos dalyviai, kolegos, ponios ir ponai, Niurnbergo tribunolo nuosprendyje paskelbta. Nusikaltimus tarptautiniai teisėjai daro žmonės, o ne abstraktus subjektai. Ir tik nubaudus nusikaltimų vykdytojus galima įgyvendinti tarptautinės teisės nuostatas. Niurnbergo procesai pradėjo naują atskaitomybės erą. Tarptautinis baudžiamasis teisingumas tapo realybė. Ši galimybė tapo reali, kai jungtinės tautos įsteigė ad hoc tribunalus, taip reaguodamos į žiaurumus iš pradžių buvusioje Jugoslavijoje, o vėliau Ruandoje. Ir galiausiai 2002 metais įsigaliojus Tarptautinio baudžiamojo teismo Romos statutui ir pradėjo veikti nuolatinis ir tikrai tarptautinis teismas, baudžiantis asmenys atsakingus už genocidą, karo nusikaltimus ir nusikaltimus žmoniškumui. Šiomis tarptautinėmis pastangomis tarptautinė bendruomenė vieningai įsipareigoja padaryti galą nebaudžiamumui, užtikrinti teisingumą, nes nebaudžiamumas už plačiai paplitusias ir sistemingas žiaurias veikas sukelia ilgalaikės pasiekmes tarptautiniai taikai ir saugumui, teisinės valstybės principams ir žmogaus teisėms. Ir šiandien mums susitinkant Vilniuje, realybė vėl reikalauja Europos ir visos tarptautinės bendruomenės vienybės. Rusijos agresija prieš Ukrainą perrašė mūsų kartos istoriją. Jau daugiau nei 2 mėnesius stebime siaubingą išpuolį prieš tarptautinę taiką ir saugumą. Išpuolį, kurį suplanavo ir įvykdė ne abstraktus subjektai, o konkretus asmenys – Putinas ir Lukašenka su savo bendrininkais. Toliau, nepaisant tarptautinės teisės sistemos ir tęsiantis karui Ukrainoje, tarptautinės pastangos patraukti atsakomybėn tuos, kurie Ukrainos teritorijoje vykdo karo nusikaltimus ir nusikaltimus žmogiškumui, tampa vis vieningesnės. Daugiau nei 10 ES valstybių narių pradėjo nacionalinius baudžiamuosius tyrimus pagal universaliąją jurisdikciją dėl karo nusikaltimų, nusikaltimų žmoniškumui, agresijos nusikaltimo. Jos renka ir saugo šių nusikaltimų įrodymus. Įkurta Eurojusto remiama jungtinė tyrimų grupė jau įkurta ir netrukus Eurojustas turės galimybę surinkti ir išsaugoti įrodymus. Tarptautinio baudžiamojo teismo prokuroras pradėjo tyrimą dėl Ukrainoje vykdomų karo nusikaltimų ir nusikaltimų žmoniškumui. Ir iš tiesų, Tarptautinis teisingumo teismas priėmė sprendimą dėl laikinųjų priemonių Ukrainos inicijuotoje byloje. Mes turime užtikrinti, kad mūsų bendri sprendimai ir tarptautiniai veiksmai būtų sėkmingi. Ir turime atsakyti į klausimą, ar turime teisinį sprendimą, kaip panaikinti nebaudžiamumą už agresiją prieš Ukrainą. Ir norėčiau pasakyti, kad tikrai matydama darbotvarkę ir tokius garbius svečius esu tikra, kad šiandien aptarsime daugybę svarbių klausimų. Kaip nubausti už agresiją Ukrainoje. Todėl norėčiau Jums palinkėti puikios dienos, galimybės pabendrauti tarpusavyje ir su kolegomis iš Ukrainos, kurie atvyko čia į Vilnių, pasidalyti su mumis savo mintimis ir pastangomis siekiant teisingumo. Ir pabaigai norėčiau pasakyti, kad kiekvienai kartai tenka savi iššūkiai, reikalaujantis savito indėlio. Ir esu tikra, kad esu jauna politikė ir galiu pasakyti, kad jau susidūriau su žiauriausiu Europos regione mano kartai kilusių iššūkių, su agresija prieš Europos valstybę Ukrainą. Ir kai ateis laikas įvertinti mūsų kartos indėlį, esu tikra, kad neliks abejonių, jog buvo padaryta viskas. Dėkoju, iki pasimatymo, slava Ukrainai.
Dabar norėčiau pasveikinti organizatorių, vieną iš atstovų, direktorių, Teisės ir demokratijos centro direktorių Dainių Žalimą įžanginiam žodžiui. Gerbiami konferencijos dalyviai, kolegos ir draugai, ponios ir ponai. Man tikrai džiugu galėti Jūs pasveikinti šiame labai svarbiame renginyje Vilniuje ir norėčiau dabar padėkoti Jums visiems už tai, kad radote laiko savo tik tai įtemptose darbovietėse, kad skirtumėte aptarti labai svarbiai šios dienos konferencijos temai, tarptautiniam teisingumui. Mes visi siekiame teisingumo ir tai yra vienas iš teisinės viršenybės ramsčių ir mūsų šiuolaikinės civilizacijos esminė savybė. Vilnius yra ypatinga vieta tokiai konferencijai. Lietuva pati yra nukentėjusi nuo 2 esminių 20-ojo amžiaus agresorių – Trečiojo Reicho ir Sovietų Sąjungos, nuo kriminalinių totalitarinių režimų, nacizmo ir komunizmo. Ir dėl to nestebina tai, kad Lietuva visada pabrėždavo būtinybę užtikrinti veiksmingą teisingumą ir užtikrinti atsakomybę už agresijos nusikaltimą. Nesvarbu, kas jį vykdytų, ar naciai, ar sovietų režimas. Ir dėl to neatsitiktinai, kad šiais metais Lietuvos tarptautinis tribunolas sovietų įvykdytiems nusikaltimams įvykdyti buvo surengtas. Mes šiandien remiame visas vyriausybės siekiant teisingumo ir tikimės, kad mūsų civilizacijai neteks patirti tokių iššūkių mūsų žmonių teisėms ir pluralistiniai visuomeniai. Kodėlgi Lietuva yra tokia empatiška ir vykdomiems žiaurumams ir kodėl jinai taip pat jaučia tokius žiaurumus patiriančių asmenų kančias. Dėl to, kad mes patys patyrėme sovietų vykdomą agresiją. Aš galiu atsiminti, kad nuo 2014 metų, kai Rusijos agresija prasidėjo Ukrainoje, Lietuva padarė gerokai daugiau, negu buvo būtina arba buvo tikimasi. Ir jinai įvedė sankcijas atsakingiams asmenims už šią agresiją. Pavyzdžiui, be Ukrainos Lietuva buvo vienintelė šalis, kuri išdrįso išplėsti sankcijas Konstitucinio teismo teisėjams už tai, kad Rusijos Konstitucinio teismo teisėjams, kurie sankcionavo Krymo aneksiją. Šiandien negalime galvoti, kad karas Ukrainoje yra tik tai karas prieš Ukrainą. Sunku būtų įsitikėtis, kad žodžiai, kurie buvo išsakyti Niurnbergo tribunole 1946 metais ir vėl bus tokie aktualūs ir šiandien. Kokie yra tie žodžiai? Karas yra apibrėžiamas kaip iš esmės blogis ir to blogio pasiekmės pajaučia visas pasaulis. Tuo metu Niurnbergo teismas pabrėžė, kad tai yra ne vien tik tai tarptautinis nusikaltimais. Kalbame apie vyriausiai tarptautinį nusikaltimą, kuris iš esmės skiriasi nuo kitų karo nusikaltimų. Tik ta prasme, kad jisai pats sukaupė visą blogį savyje. Ir dabartinė tęsiama agresija prieš Ukrainą kaip tik ir pademonstruoja, kad tai yra tiesa. Yra dar vienas svarbus dalykas. Yra dar vienas dalykas, kuris tikrai prikausto visą tarptautinės bendruomenės dėmesį. Mes norime užtikrinti nuolatinę taiką ir draugiškosius santykius tarp tautų. Ir būtent dėl ideologinio, tai yra ideologinės nusikaltimo kontekstas. Tai yra Rusijos elito, ir taip pat ir Baltarusijos elito autoritarinių režimo pasiteisinimas, kodėl jie vykdo šitos nusikaltimus. Panašiai kaip fašizmas ar nacizmas, tos idėjos gali būti suteiktas rusizmo sąvoka. Jas galima apibūdinti kaip tam tikras ekletinis nacistinės ir sovietinės ideologijos postulatų rinkinys. Visada šlovinant buvusią sovietinę praeitį, iš esmės paneigiant teisę tokioms tautoms kaip ukrainiečių ar baltarusių teisę egzistuoti kaip savarankiškos tautos, atmetant bet kokią galimybę savarankiškai šalims spręsti, buvusioms Sovietų Sąjungos Respublikoms spręsti savo likimą. Iš esmės, rusizmas atspindi cinišką tarptautinės teisės ignoravimą, nacionalinę neapykantą ir neapykantą mažumoms, žmogaus laisvės ir gyvybės sumenkinimą ir nuvertinimą. Dabar vykstant agresijai prieš Ukrainą, mes turime pažiūrėti, ką sako mūsų pagrindinės mūsų civilizacijos vertybės. Mes turime rasti patį geriausią būdą, kaip patraukti atsakomybę ant tuos, kurie atsakingi už tokių nusikaltimų vykdymą. Turime įvertinti visą tą ideologiją, kurios pagrindų ta agresija yra vykdoma. Mano nuomonė, ši konferencija yra labai nedidelis, bet reikšmingas žingsnis teisinga linkme. Linkme, kuri leis mums įsteigti specialų ad hoc tribunolą. Norėčiau palinkėti jums labai sėkmingų diskusijų, ieškant ir stengiantis užtikrinti teisingumą.
Dabar norėčiau pakviesti į atvirą šios tarptautinės konferencijos diskusiją ir sekantį laiką skirsime pagrindiniam klausimui, kodėl teismas už agresijos nusikaltimą yra gyvybiškai svarbus tarptautinės bendruomenės išlikimui. Norėčiau pasveikinti diskusijos dalyvius. Norėčiau pradėti nuo Vytauto Landsbergio, nuo pirmojo atkurtos Lietuvos valstybės vadovo. Norėčiau pristatyti Valdį Zatlerį, buvusi Latvijos prezidentą. Sebastian Kaleta, Lenkijos Respublikos Teisingumo ministerijos valstybės sekretorius. Per nuotolį prisijungs Juri Ratas, Estijos parlamento pirmininkas. Šiek tiek vėliau turėsime galimybę išklausyti vaizdo kreipimusi. Visų pirma, pono Dmitro Kulebos, Ukrainos užsienio reikalų ministro, buvusio Jungtinės karalystės ministro pirmininko Gordono Braun ir Maris Lauri, Estijos teisingumo ministerijos. Aš esu žurnalistė, be to moderuosiu šią diskusiją. Pradėsime nuo įžanginių pastebėjimų. Tų diskusijos dalyvių, kurie čia kartu su mumis, profesoriau Landsbergi, norėtume pradėti nuo jūsų.
Ladies and gentlemen.
Labas rytas, ponios ir ponai, mėly kolegos. Pasinaudodamas savo privilegiją, aš kalbėsiu lietuviškai.
Civilizacija arba vadinamoji vakarų civilizacija atsidūrė keistoje savo raidos padėtyje. Galų gale tai jau tikra krizė. Fetišizavusi protą ir teisinius buvę pagrindus, ši civilizacija manė kurianti, gal net sukūrusi, pamatinėmis bei visuotinėmis taisyklėmis grindžiama tautų gyvenimo modelį, neva jau tarptautinį. Teisė ir teisingumas turėjo būti atramos tam tiltui į šviesią ateitį, be tironijų, be jėgos kulto. Tam turėjo rastis kitoks žmogus, o jo raida strigo ir užtruko. Šėtonas netobulą žmogų stumdė po visokius klystkelius, kad tik neateitų ir nežvelgtų pats į save. Valdžios ir prabangos tuštybė, malonumų geiduliai, kokie niekai. Atėjome iki veislės išlikimo klausimo, ar apskritai įmanoma sukurti visiems, bent jau daugumai, priimtiną primestinį tautų šeimos koegzistencijos modelį. Jis saugotų didžiausią tautų būvio turtą – taiką. Taiką be viešpatavimo ir leistų tęsti tobulinimosi paieškas. Tokia būtų žmonijos savikūra. Gerosios valios ir artimo meilės principais. Krovės kontekste tu ironiškai. Tai ne patyčia, bičiuliai. Tegul šie principai bent jau nebūna pasmerkti kaip kontrrevoliuciniai ir nelydimi šauksmų nukryžiuok. Protas ir teisė, racionalizmas, švietimiečiai. Palikim vargšą protą kiek pailsėti, tiek daug pasiekusį. Neerzinkim nei apleistos žmogaus širdies. Pasidarykim po teisės lankas. Ar yra kokia pirmenybinė, prioritetinė teisės nuostatų sistema, kuris skelbtųsi žmonėms pati geriausia? Nepaisant to, kad ponai žmonės tą ir te daro, kad stengiasi jos išvengti, ar bent nusukti į kokį partikuliarų kampą. Pagauk kampą, ne veltui radosi toks posakis. Vis dėlto siekiame teisės pagrindų, tariamo visuotinumo, universalizmo. Galbūt tada žmonija galėtų dar išlikti. Bet ar tikrai iš tiesų juk siekėme kitko? Ta kaip tik rodo pastaroji pasaulio įvykių vadinamoji politinė raida. Čia brendam jau į valdžios konceptų ir pagundų balą. Toje baloje valdžių struktūros arba sistemos ima viena kitą už gerklės. Aš geresnė, aš geresnė. O teisė tarnauja kaip dantis. Bet ar perkasim savo prisiraizgytus raizgalus? Atidėjus juos amžiams į pasakų muziejų, tektų kritiškai peržvelgti pastarojo šimtmečio utopinius raistus. Viena tų utopijų, kaip žmogui išlikti, nesikeičiant iš esmės, bet neišsinaikinant. Ji buvo pavadinta kapitalizmo ir komunizmo konvergencija. Tai sviesto ir mėšlo miksas, projektuojant sukurti produkto dvigubai daugiau, bet to visai naujos kokybės postmodernaus sviesto. Berods jį ir valgom. Tačiau dabartis rodo kitą realesnį kelią, kuris gali tapti visišką tikrovę. Tai pripažinti, kad komunos ir demokratijos miksas nerealus. Atvirai siekti pasaulinės šnipų ir jėgailų diktatūros. Šį pasirinkimą programuoja ir propaguoja stalininė, putininė Rusija. Žiūrėkit, geresnė sistema, efektyvesnė, o naivuoliai telaukia savo likimo. Iš to ir paveldėtas stalinistinis teisės, kabutėse, supratimas. Teisinga, gera, reliatyvios atgyvenusios sampratos. Galbūt už jų šmėkšo net pasaulinio masto melagių diktatūra. Todėl ir mikso jungtinės tautos yra laikinas akių dūmimas, gynybos laiko nuostolis arba agresorių pelnas, rengiantis išsvajotam gaublio užkariavimui. Demokratijos viename krepšy su diktatūromis. Ar dar nematom, kaip tai beviltiška? Demokratijos diktatūrų bijo. Tai yra, demokratijos bijo diktatūrų. O diktatūros demokratijų nekenčia. Tai komunos paveldas. Demokratija esanti mat apgaulė. Tai slaptoji buržuazijos diktatūra. O tironų klano diktatūra yra tikroji demokratija. Valdoma ar dar kokia nors. Tikroji demokratija, nes atstovauja liaudės arba darbininkų interesams. Tai senovė. Net Gorbačiovas jau suprato tą leninizmo demagogiją. Gal jo patarėjas Aleksandras Jakovlevas mėgino aiškinti, kad gensekas pasiūlė komunistams pašalinti iš programos tokias kvailystes. Savo ruožtu tenka suvokti, kad saugumo tarybos ir Jungtinių tautų organizacijos reforma, kurią Lietuva siūlė generalinėje asamblėjoje jau 1992 metais yra praleista proga. Jungtinės tautos nenori reformuotis, tapti veiksnia organizacija. Ji nutarė verčiau mirti. Ukraina stebi šią beviltiškumo agoniją ir priešinasi, primindama, kad egzistuoja dar orumas. Tai, kas ten vyksta, ne veltui vadinama orumo revoliucija. Tai pasaulinio masto dalykas. Gal negyvensim, bet nevergausim. Sutinkantieji vergauti be orumo jau kitas pasaulis, alternatyvus pasaulis. Taigi jau dabar du pasauliai ir mikso nebus. Arba Volodya, arba Pranciškus. Tikrovės pasauliui šiandien atitiktų nebe viena, o dvi jungtinių tautų organizacijos. Žmonių ir žmogėdrų. Galbūt vadas Putinas to ir siekia. Tik labai abejotina, ar diktatorių jungtinėse tautose, sutrumpintai DJT, jis be griežtų pirmojų smuikų. Taip gimsta realizmas.
This is how reality comes to life.
Pasaulis.
The world which has been forced to attend mandatory lectures of Professor Putin has started to get the message that the former concepts of this law, such as the law of the nations, international law, international humanitarian law, in the cases of wars, have already been inventorized as obsolete items. I believe it happened back in 2014. So we have two spaces, the space of lawfulness and lawlessness. And that would very much reflect the two types of dictators, United Nations, and democracies, United Nations. If we follow the previous framework of the philosophy of law, and I believe we still want to be living in the relative background of international law, we need to remember the contribution made by Lithuania after it broke free from oppression. I'm not going to say any news. Allow me to remind you of the old facts. The Second Republic of Lithuania in 1992 in the United Nations addressed republics of the world. Let us call a spade, basically call the crimes committed by the Red Army dictators their true name, at least in the territory of the former USSR. Let us describe, identify, and define what has been done. And later we may say, oh, never again. Unfortunately, none of the single states responded to Lithuania's call. Back then, Lithuania at least did its homework in its own legal system. Since 2000, we have a law on the damage done by the occupational forces. because the liability of aggression and occupation still remains an abstract notion for those who like preaching or praying. Whereas, in order to make something real to happen in the real world, we need to be very preventive. We need to take preventive actions. And such specific actions is no longer a notion of guilt, which is highly declarative in its nature, on the basis of which the International Tribunal might take place. And this notion of guilt could be a sermon to Tomcat Vasa, who stole your ham and continues to eat your ham while listening to your sermon. But it's only the sums and the figures help us to define the damage done by the crimes, as well as an undertaking or commitment for the states what they should do about this damage sustained. At least to speak up, not to be silent, brothers and sisters. Nowadays, we have a dream or the lights in front of us, an ad hoc tribunal which is going to introduce commitments to the governments of the state. These are our attempts at the moment, and you may know everything is still where we have started from. Then we may expect a great sport of words to start. The high-level Putin's accomplices are already preaching that the winner takes it all. There is no guilt or no liability for the winners, which would mean that Putinoids, it would be a subversion of anthropoids, simply cannot be subjected to Nuremberg tribunal. But let us compare a very simple statement. The winners are not guilty. Would we agree to this statement? By establishing this tribunal, we would need to answer to these questions from the very beginning, as well as to consult the deep thinkers of the deserts, for whom or through whom the Holy Spirit preaches. Thank you for your patience.
Thank you, Mr. Vytautas Landsbergis. And now I would like to welcome President of Riigikogu Estonian Parliament, Jüri Ratas, because I know that he'll have to leave us at 10. We can hear you. Still can't hear you.
You can imagine us.
Is it okay?
Now it is okay. Yay!
Excellent, thank you. Russian attacks on Ukraine is not merely another local high-intensity armed conflict. A full-scale invasion of independent Ukraine with the use of its full arsenal alongside Russians' demonstrable grave breaches of all possible rules and customs of war is in fact an attack on the whole of Europe, the world democratic world, and attack the rule by law order, world order. On April 21st, the Riigikogu Parliament of Estonia unanimously adopted a statement on the Russian Federation's war crimes and genocide in Ukraine. In its statement, our Parliament recognizes as an act of genocide against the Ukrainian nation the actions committed by the armed forces of the Russian Federation and urges another national parliaments and international organizations to do the same. The Riigikogu also calls for support to the investigation of these crimes, the prosecution of the perpetrators, and the establishment of an international court of this purpose. Now, we believe some practical steps should be taken. Estonian Parliament proposes to establish a special court, tribunal, for the prosecution and punishment of the crime of aggression, genocide, crimes against humanity, and war crimes committed in Ukraine by the major criminals in a position effectively to exercise control over or to direct the political or military action of the Russian Federation and Belarus since 20 February 2014. I'm also proud to inform you that Estonian Parliament has started the process of drafting the statute already. We invite all countries to join our efforts. The war that Russia is waging in Ukraine is a war of civilizations. It is frontier between the past and the future, democracy and barbarism. The path the world will have to walk now depends on all of us. Thank you for your attention, and I must apologize because I must leave. I have the next duties. I'm today in Latvia, and we are celebrating here Baltic Assembly cooperation. Thank you for your attention once more.
Thank you, Jüri Ratas, President of Riigikogu, Estonian Parliament, and he mentioned Latvia, and we have the former President of Latvia, Valdis Zatlers. And now it's your time for introductory remarks.
Good morning to everybody. It's my honor to be here, and thank you, the organizers, for giving me this opportunity to share my views. When we see aggression and we see war crimes and we see genocide in Ukraine, the first reaction, we should punish them. And we all are starting to consult each other how we can do it in a legal way and in a fair way. But it's very important to understand the background, why it happened, what was the reason and the purpose of the Russian aggression. And we look in the history, that during the last 25 years, the only ideology of the Russian state has become militarism. I have lived in half of my year in the Soviet Union, and there was no 9th of May in the Soviet Union. There was the 1st of May. That was a celebration of labor and peace. And the slogan was, peace to the world. It has changed. The ideology of Russia is not the same as the ideology of the Soviet Union. So it's even much, much worse. What does it mean, Even a few years ago, when we were looking at the Russian TV, it was clear that Russia the Kremlin is preparing their own population to war. They have prepared the people as they are today, that they accept war as a normal status of their lives. And that is dangerous. From the other point, Russia didn't pay anymore any respect to any international agreement, treaty, or international law system as a whole. They didn't respect Helsinki, one of the most important legal acts in the history of Europe. They didn't respect Budapest memorandum, about Ukraine, even being the signatory of this document. They didn't respect, the conventional forces. Conventional forces agreement in Europe. That means the conventional military restrictions for the conventional forces. They said, nobody is going to tell Russia where they put their own military forces in their territory. So, and we can count and count and count. They don't respect the United Nations. They don't respect except one thing, the veto in the Security Council. All the other is not important for Russia. They don't respect the Secretary General of the United Nations. They don't respect Pope Francis. They don't respect anybody. So we have to understand that we are dealing with a hooligan in politics, hooligan in economy, hooligan in a military sphere. It means a person who doesn't care about anybody else except himself. And the arrogance is a total arrogance. So what we can do? At first, this conference is devoted to the term crime of aggression, because it hasn't been any case except Nuremberg. Then we had a trial on crime of aggression, genocide, and crimes against humanity. It's important to create this international tribunal, and it must be done by efforts of everybody all over the free world, because why it's so important. If we look at the steps we need to go, the first is to stop the war. Of course, everybody understands that. Then the second step is, to set up peace somewhere. So we have to find the evidence of crime of aggression, and the tribunal will have its decision, guilty. When Russia is guilty for all these crimes of aggressions, then the next step is confiscation of the frozen assets in the Western world. And the next step is to use these assets for rebuilding Ukraine. And that's a restitution. It's very simple. And of course, the money will not be enough. All our European countries and the Western countries must set up some Marshall Plan for rebuilding Ukraine. And Ukraine must become 100% part of the European Union. There's no other way. Because if we want to prevent the next war, we have all understood that it's only by restoration of Ukraine's territorial integrity, 100%, including Crimea. If we don't do that, the next war will come. The stakes are very high. Now about the tribunal. Many people want to say that something like Nuremberg. It's not like a Nuremberg. It's different. Why? After the Second World War, Japan and Nazi Germany were defeated. The armies were destroyed. The military infrastructure was destroyed. Their economies were destroyed. And their future armed forces were limited, very limited to self-defense functions, and that's all. In this case, there has not been any war battle on the soil of Russia. I will even say more, since the 1941, nobody has attacked or threatened Russia except island of Damansk by Chinese in the 60s. So there is no reason to attack. There was no reason to attack Ukraine, but there was a purpose. And the purpose was genocide and military might of Russia. And it shows also one mistake we have done in the history. Königsberg, Kaliningrad. It was given to Russia, and now we have a problem of Suwalki Corridor, military problem of Suwalki Corridor. We have to start to speak about what we have to do with Kaliningrad. Because according to the treaties, it should not be a territory of Russia anymore. So Russia has this full military infrastructure. They can recreate their army. There is no civilian damage. There is no damage to civilian infrastructure. The only damage to Russia are casualties in the war. So the situation is absolutely different than it was when the Nuremberg Tribunal was taking place. So, tribunal will not be enough. We have to think in a much larger scale. What we can do with Russia. Everybody is excited about sanctions, and they say in the long run they will work. I'm not so sure. Look at the Northern Korea. Absolutely isolated. Still they have all weapons, missiles and even nuclear weapons. So they will not work. They will help to let's say, to minimize the efficiency of Russian economy, but they will not work. Because we are again dealing with a state whose ideology is a militarism and no another. It's not a question about the state of values, state of rule of law, welfare state or innovation state, No, just militarism, military might. So we have to destroy this ideology. And the question is, nobody knows how. And the only answer is that according to the history, it happened always when the aggressor was defeated in the battlefield. And we have to understand that it's not just fun giving heavy arms to Ukraine. It's absolute necessity. Because only defeat in the battlefield may be a trigger for destructing this ideology of Russian state. And nobody knows what will be after the war. Even if the Russia withdraws from Ukraine totally, maybe it will become even more dangerous state to all ourselves than it is today. It sounds, how far we can go. Russia can go much, much farther. So far we will allow them to do. So, and please think about the legal framework, how to get back Russia to respect to the international law system. It's very important because we have to create this post-war legal system in Europe, and this system must be respected by Russia. And I would say a very, very strange thing. If something changes in Russia, the ideology I mean, we must think about such fantastic thing like a Marshall Plan for Russia. What kind of Marshall Plan? Nobody knows today. But the failure after the collapse of the Soviet Union to assist Russia to become a democratic country brought us to the Russia with a military ideology and aggression as its everyday life. So let's not repeat the mistakes of the past, but end up with the thing, punishment is only one part of the solution. We need a sustainable, long-lasting solution for peace and stability in Europe. Thank you very much.
Thank you, Valdis Zatlers, former president of Latvia. And last but not least, in Vilnius here we have the panelist Sebastian Kaleta, Secretary of State at the Ministry of Justice of the Republic of Poland.
Thank you. I would like to thank you very much for the inviting me to the conference and giving the opportunity to speak on this highly topical issue. The Russian aggression in Ukraine is an event unprecedented in the last 70 years and has very serious consequences for the international order, as well as involves the suffering of innocent people. I would like to express my special thanks and appreciation to the Minister of Justice of Lithuania for preparing a conference dedicated to this extremely important initiative, the starting point of which is the absolutely right idea of not leaving all the most serious crimes committed by Russia against Ukraine unpunished. The military aggression of the troops of the Russian Federation against Ukraine undoubtedly constitutes a grave violation of international law, as it violates its fundamental principle prohibiting the use of armed force against the sovereignty, territorial integrity, or political independence of any state. This principle is mentioned in the Charter of the United Nations and in the 1970 UN General Assembly resolution, formulating the basic principles of the international order. The UNGA resolution not only prohibits the use of armed forces as a means of settling international disputes, but also makes clear that aggression is a crime against peace that triggers responsibility under international law. Despite calls from the international community, Russia has not stopped its hostile actions. There are still attacks in close proximity to our borders in which civilians die, innocent women, the elderly, people with disabilities and children are killed. Civilian facilities, including hospitals, schools and shelters, are attacked. Since the beginning of the aggression, the Polish government has condemned actions against the sovereignty and independence of Ukraine, as well as focused significant organizational and financial efforts to host millions of Ukrainian refugees, people directly harmed by the crimes occurring across our eastern border. The Polish Minister of Justice and law enforcement agencies have also taken measures within their competence to prevent the perpetrators of these crimes from going unpunished and to document these crimes. By order of the Minister of Justice, the Prosecutor General, the Polish Public Prosecutor's Office initiated criminal proceedings, the object of which is the initiation of a war of aggression directed against the sovereignty, territorial integrity and political independence of Ukraine by the armed force of the Russian Federation, including jointly in agreement with the authorities and officials of the Republic of Belarus that make the territory of that country available for the performance of acts of armed aggression against Ukraine. One of the aims of this investigation is to collect and preserve evidence in the form of testimonies of Ukrainian refugees who are currently residing in Poland as war refugees and who are either direct civilian victims of war or who have knowledge of war crimes that occurred on Ukrainian territory from various sources. To date, more than 1,000 people have already been interviewed as witnesses. The activities of Polish Public Prosecutor's Office include a process of continuous search for persons who may constitute sources of evidence in the ongoing investigation. Special websites and phone lines have been set up for this purpose. A special information campaign in Polish, Ukrainian and Russian is being conducted throughout the country in the form of announcements, notices and websites about opportunities to testify before Polish public prosecutors. In order to identify other persons whose testimony may be relevant to the investigation and to interview these persons, public prosecutors and service officers use contacts with social and humanitarian organizations that provide assistance to refugees from Ukraine. Regardless of the actions taken by the Polish Prosecutor's Office within the framework of the national investigation, Poland actively participates in the joint investigation team established together with Ukraine and Lithuania, with the ICC prosecutors. ICC prosecutor also joined this team. The team's main goal is to coordinate activities related to the collection and preservation of evidence of crimes committed on Ukrainian territory in order to hold the perpetrators criminally liable. It should be pointed out that this is precisely the cooperation as a joint investigation team that is very effective, because it is not limited to the direct collection and exchange of information and evidence without the need to ask for legal assistance, but above all, it gives the team members the right to participate in all procedural activities carried out outside the territory of their home state. The ICC prosecutors' accession, which is unprecedented, is critical to the effectiveness of the team's work in terms of using its findings directly for ICC proceedings. In view of the above circumstances, I appeal to countries that would like to further support the ICC prosecutors' investigation and assist in documenting crimes on Ukrainian territory to join the already existing joint investigation team. And as far as I know, some more countries declared to join the team, and maybe in the next weeks we will meet them there. From the very beginning, the government of Republic of Poland has attached particular importance to supporting the ICC prosecutors' actions. The support was reflected not only by the visit of ICC prosecutors to Poland and organizing conditions for the activities of the special operation team he appointed, the aim of which was to prepare the ICC investigative activities and assess of the situation related to the mass influx of refugees from the territory of Ukraine. Russia's aggression against Ukraine is an event of great importance for the international community, which has not yet overcome the global effects of the COVID pandemic and has already faced the consequences of Russian war against Ukraine. Unfortunately, the whole world will suffer the consequences of Russia's unlawful attack on Ukraine, and the effects of this attack are already visible. It is the suffering of civilian population and enormous destruction of Ukrainian towns and villages. It is the migration crisis and that the countries bordering with Ukraine are struggling with. But the effects of the war are visible all over the world. It is a famine for millions of African people for whom Ukraine and Russia were suppliers of basic agricultural products. It is also a huge rise in food prices and an inflation that is taking global proportions. Therefore, Russian aggression cannot remain without an answer from the international community. I would like to emphasize that Poland fully supports the investigation opened by the ICC prosecutor to bring justice for the crimes that have occurred and continue to occur on Ukrainian territory, especially war crimes and crimes against humanity. I would like to express my conviction that the International Criminal Court is the most appropriate international body for the impartial adjudication of these crimes. Unfortunately, the ICC mustn't prosecute the crime of aggression. First, Poland is open for debate concerning the established an ad hoc international criminal court with a mandate to investigate the allegation crime of aggression committed by the political and military leadership of the Russian Federation against Ukraine, because, as I mentioned before, ICC has no enough jurisdiction on that. Such a special court should be international in character, which means it should be established by organized international community and operate on the basis of international law. Bearing in mind the limitations of the United Nations Charter, it is worth considering it would be created on the basis of multilateral treaty adopted by the UN General Assembly. The support of Council of Europe, the European Union, and other international organizations would be needed. However, I think we should be aware of problems associated with this very ambitious and difficult challenge from the outset. Identifying and discussing these problems as early as possible will, in my view, contribute to preventing impunity for those most responsible for the gravest crimes against peace to which Ukraine has fallen victim. I believe that this meeting, bringing together distinguished academics, government representatives, and civil society, is the best forum to address this discussion. Thank you.
Thanks, Sebastian Kaleta, Secretary of State of the Ministry of Justice of the Republic of Poland. And now we'll hear 3 video addresses in a row from a highly profiled politicians, and the rest of the time will be dedicated to the questions and discussion, and I encourage audience, while you are listening to the video addresses, if you have any, we can discuss it later. Let's start with Maris Lauri, Minister of Justice of Estonia.
First, I would like to express my gratitude to the organizers of this conference. The topic of the conference is extremely important. Ukraine is fighting for its freedom and, to be honest, is fighting also for the free and democratic world. The people of Ukraine are suffering from unprecedented military aggression.
Aš atsiprašysiu, gal galėtumėm sustabdyti ir pasižiūrėti su garsu, nes niekas nieko vis tiek negirdi. Technically.
Every week and every day we can see evidence of the crime. The attitude by the Russian Federation is, however, not surprising for me and many others. Its military forces continue to target civilian infrastructure and civilian population, and authorities justify and encourage this. Denial of the atrocities committed against Ukraine and its people show us clearly that international community must stand firmly. It is important to continue our support to Ukraine and its people. We need to make sure that Ukraine can defend itself against the aggression and prevent further atrocities in its territory. However, we cannot look past what has already happened and what crimes have been committed.
There is a suggestion to stop listening because it's kind of hard to understand what she's saying, and to switch to the other video address. Can we do that? Yeah. Oh, okay.
Dear ladies and gentlemen, I'm grateful to the organizers of this international conference, in particular to Lithuania's Ministry of Justice and the Law and Democracy Center Justice Hub. 80 years ago in London, representatives of 9 nations signed a declaration that paved the way for punishing those responsible for crimes against peace, crimes against humanity, and war crimes perpetrated during World War II. This crucial document laid the foundation for international criminal justice, tasked with reinforcing the prohibitions of genocide, crimes against humanity, war crimes, and the crime of aggression. 8 years ago, Russia committed acts of aggression against Ukraine. President Putin violated the prohibition of the use of force against political independence and territorial integrity of another state, as well as the right of all people to freely determine their political status and freely pursue their economic, social, and cultural development. On February 24th, Russia launched a large-scale war of aggression against Ukraine. Putin has publicly set out his motives for this move. They boil down to him denying the right of Ukraine to exist as a nation and as a state, clearly indicating his genocidal intent. Over 2.5 months, the Russian army has committed numerous crimes against humanity by indiscriminately attacking civilians, repeatedly violated international humanitarian law, and committed numerous war crimes. Massacres in Bucha, Irpin, Hostomel, Borodyanka, and the humanitarian disaster in Mariupol require a prompt legal response by the international community. Russia's war crimes and crimes against humanity are already being investigated by the International Criminal Court upon referral by 43 states, and following Ukraine's consent to ICC's jurisdiction over all crimes committed during the armed conflict since 2014. Ukraine is strongly committed to cooperating with the Office of the Prosecutor to achieve justice for all. If we look at this historic record of international criminal justice, there have been important achievements in addressing genocide, crimes against humanity, and war crimes. But there has been limited progress with regards to the crime of aggression, or, crimes against peace, as labeled during the Nuremberg Tribunal. Unlike other core international crimes, the International Criminal Court faces objective difficulties in gaining jurisdiction over the crime of aggression. Existing rules do not allow the court to address Putin's aggressive war against Ukraine in the absence of Russia's ratification of the Rome Statute and amendments thereto. Ukraine is also seeking redress at other available international fora. In March, the International Court of Justice ordered Russia to immediately suspend military operations and ensure no furtherance of them. The European Court of Human Rights ordered Russia to refrain from military attacks against civilians and civilian objects. Now, the time has come to complete the architecture of international criminal justice initiated by the 1942 London Declaration. We need to fill the gap and establish a special tribunal with a specific jurisdiction over the crime of aggression against Ukraine. Ukraine has already endorsed the proposed declaration and the statement calling for its establishment. Hundreds of European and global intellectuals, as well as international lawyers, have already signed and supported it. Global petition in support of the initiative has already received almost 2 million votes. Such broad global support demonstrates that the momentum to proceed is certainly there. I want to make it clear. This effort is not meant to replace any of the existing international courts and tribunals dealing with various aspects of Russia's aggression and other violations of international law. But none of them would ever arise without the mother of international crimes, the crime of aggression. The establishment of the Special Tribunal will pave the way to address this crucial deficiency. This idea is fully supported by President Zelensky, the government of Ukraine, Ukrainian lawyers, and Ukrainian civil society. There is a growing understanding around the globe that Russia's current war of aggression is the largest one in Europe since 1945, and thus the response to it shall be appropriate. The establishment of the tribunal has already begun to find support in international organizations. For instance, in recent resolutions of the Parliamentary Assembly of the Council of Europe. We are aware of relevant legal issues we may face while establishing such tribunal. But I'm confident that the legal society supported by the will of the countries will be able to overcome them. I'm confident that we shouldn't lose time and proceed with the implementation of the idea without delay. It is our duty before all people who have suffered from the Russian aggression since 2014 in Crimea and Donbass, as well as before those who continue to suffer all over Ukraine now. Furthermore, creating such a tribunal will prove that international law is a living organism able to respond not only to theoretical questions but also to arising and pressing issues. I strongly believe that this conference can give a significant impetus to the creation of the Special Tribunal for the punishment of the crime of aggression against Ukraine. I wish all participants a fruitful discussion leading to concrete and swift actions. I thank you.
That was Minister of Foreign Affairs of Ukraine, Dmytro Kuleba, and now we have one more, former Prime Minister of United Kingdom, Gordon Brown. Let's listen to him.
It is a particular honor to praise the government and people of Lithuania for their leadership in supporting morally, politically, economically, and culturally the people of Ukraine in their hour of greatest need. For being the first country to make a formal request for the International Criminal Court to consider an indictment of Russia for aggression in Ukraine, and to have led the way by assembling the evidence and mounting your own investigation. Lithuania has also been the first European Union country to lead the way in sanctions by cutting off Russian gas. And so I want to start by congratulating Lithuania's leaders for the work done, the support offered Ukraine, the encouragement given, and the difference being made. And this continues to this day with the convening of this very special conference. Today I join Lithuania in calling on all people of decency and humanity to support the call made by President Zelensky for the establishment of a special international tribunal to investigate war crimes committed by Russian aggression on the territory of Ukraine. Such an initiative, through which a group of states would set up the tribunal on the basis of a multilateral treaty, has in the last few days received the support of the Parliamentary Assembly of the Council of Europe. And it's not just strategically imperative to do this, but morally right for us to support the people of Ukraine. Buildings and lives have been destroyed, but Ukraine's unity has proved indestructible. Hearts are being broken every day, but Ukraine's resolve is unbreakable. And I want to draw to your attention the text prepared by eminent lawyers of a criminal indictment against President Vladimir Putin for initiating and executing Russia's war of aggression. It is a charge sheet detailing the gravity of the case that war crimes prosecutors could file before an international court. Already at the request of 39 countries led by Lithuania, Karim Khan, the prosecutor at the International Criminal Court, has put Putin under investigation for war crimes and for crimes against humanity. These include the targeting of innocent civilians through mutilation, torture and rape, all against international law, the bombing of hospitals, schools and public buildings, against international law, the breach of designated humanitarian corridors and agreed ceasefires, against international law. And if recent reports are accurate, the threat to use banned chemical weapons and even tactical nuclear weapons, all against international law. But while the collation of photographic DNA and documentary evidence to link Putin's orders directly to the perpetration of these evils will take months of painstaking forensic research, the crime of aggression that started some time ago with the planning and preparation of an invasion can be proven by evidence that is readily accessible and fully available now, and can lead, as the author of this initiative, Professor Philip Sands, has argued, to the laying of charges against Putin within weeks. Aggression is indeed Putin's original crime. It is the crime identified in the declaration made by Allied countries in London in 1942, in what prepared the way for the Nuremberg trials of 1946. They pledged to bring Hitler and his inner circle to justice for what they called crimes against peace. It was at Nuremberg that aggression was defined not only as an international crime, but as the supreme international crime. The crime that, quotes, contains within it the accumulated evil of the whole. Now, while a gap in the law means the ICC cannot hear a case against Russia for aggression, indeed neither Ukraine nor Russia are signatories to this statute of the ICC, a special tribunal can be constituted at the behest of Ukraine and supportive states. And that is what, with the engagement of the Ukraine government, nearly 2 million people have signed an international petition, 50 former presidents and prime ministers, 100 international lawyers and public officials representing every continent have joined together to request. Now, to those who say such a tribunal can never happen and we're on a fool's errand in the hopeless pursuit of a justice we cannot achieve, let us remind people that the indictment of 1942 was dismissed as an impossible dream. But not only did Nuremberg bring the prosecution of Hitler's henchmen, but in the last 20 years, war crimes in Yugoslavia, Rwanda and Liberia have been prosecuted, and the former Liberian leader, Charles Taylor, now languishes in a British jail after being sentenced to 50-year imprisonment for his crimes. Shocking atrocities that are now being documented by the day have made such an indictment against President Putin more urgent. In the face of the escalation of Russian aggression, allies of Ukraine will now have to extend sanctions and travel bans to intensify humanitarian aid, not just anti-tank missiles. But even then, Putin may still feel he can act with impunity. So it is time that our message that the civilized world will not stand aside, but pursue him round the world, and that he will not escape punishment, and that the Putin inner circle must be warned that they are also liable to punishment for crimes in which they have been complicit. Perhaps even more important, such an indictment now would send a message to the people of Ukraine that we will not allow war crimes to go unpunished or unprosecuted. To secure justice, the rule of law, and the triumph of good over evil. Thank you very much.
That was a former British Prime Minister, Gordon Brown, and we have like 9 minutes until the coffee break that you are waiting, I guess. But we still have 9 minutes to go, and as I mentioned before the video addresses, the audience is encouraged to ask the questions to our panelists that are sitting right here in Vilnius. Do we have any questions? Yes, we do. I can give you my microphone. Be faster.
Good morning to everyone. My name is Inga Martinkute. I'm a lecturer and advocate here in Vilnius. I wanted to ask, first of all, what are the differences in the global situation and the context between Nuremberg and the current possible special tribunal for Ukraine? I understand that it's easy to feel comfortable in a conference like that with like-minded people who are horrified by the events in Ukraine and by the violence committed by Russia in Ukraine. But I also am very aware that there are people around the world that are not so sympathetic. And the main challenge for such international tribunal will be the legitimacy, how to ensure the legitimacy. Nuremberg Tribunal had a very different circumstances in which it was established than today's world. And I'm having in mind China. So how do you see, how do you perceive what were the circumstances back then and whether the success of Nuremberg can be repeated today?
Who wants to answer?
Very, very comprehensive question, but I'll answer just about China. At first, Putin's multipolar world means what Professor Lambert just said, it means a union of dictators. But multilateral world is represented by the Western world, like United Nations. China will follow its interests, and it will be very patient, and they will leave the Western world to prosecute Russia with no intervention, because it's a Chinese approach. They are patient, they will wait, they will see the result and get profit from this result. I'm not talking about the rest of the world, because the rest of the world is not so important. That is a similar situation like in 45, yeah.
Mr. Kaleta, do you want to add something?
If we look from the legal basis, circumstances, if we think on establishing ad hoc tribunal for the crime of aggression, there are, I think, three different paths. And you mentioned China, and the first path, I think, is completely impossible, the path through the Security Council. The second path is through the General Assembly, which I mentioned, but there is a need for 2 out of 3 numbers of members of United Nations, and this makes legitimate decision. This would be legitimate decision, but I think it would be a very big task for us to convince this number of countries to support such initiative, if such initiative would be presented there. But this is an option. And the third way is the simple multilateral international treaty, but the legitimacy of such a treaty will be restricted to the countries which signed this treaty. So from our perspective, if we look for special tribunal, we should seek the number 2 opportunity. But as I spoke before, it's not easy, because there needs to be a majority of countries of the world which will be interested to prosecute this crime of aggression. But from the current legal basis, there are perspectives for that.
Mr. Landsbergis, do you want to add something?
We should realize that there are 2 two legal spaces, two legal spheres, and to stop talking about allegedly one. China is a good example. Of course, we can say that Russia is out of normal international community. But they may say, maybe Chairman Xi will agree that that is too great pretension. Why do you think that you are legal? You are calling it is a tradition that the Western system is legal and it can be, should be seen as a model for the world. I see that Mr. or Professor Putin now is going with a lecture that these things are different. They are two legal spaces, while one of them should not be treated legal. If we want to survive, we have to come to realities as soon as possible, stating that that mentality, that type of action and being, as is now implemented by Professor Putin, is not for us. Who are we for us? If we are the democracy world, what we do treat as a normal world, and community of normal nations, and if United Nations would be organization of normal nations, then the situation would be more clear. We are still in self-confusing system of mentality and vocabulary. What to say about those soldiers of Professor Putin and what they are doing now in Ukraine? Are they humans yet? Or maybe not. President of Lithuania, Nausėda, asked publicly what a word should be used for them. Humans or not humans? No, we could say Putinists or Putinoids. It would be good. Not anthropoids, but Putinoids. Because they behave not as humans. And that is a line of division in current world between humans and not humans, or I could say cannibals. Humans and cannibals. We now have to deal with cannibals. And it would be better to realize that they are of different mentality. They use different vocabulary. But they so often successfully confuse us because we would like to have the common vocabulary. There's no common vocabulary. Vocabulary is not the sound only. Vocabulary is the content. They're using the same words, but the content is very different. Probably we will have to come this course of education by Professor Putin in quite a long way. If this system is not stopped, blocked, isolated from what we would like to see as a sound world, insane world, okay, but where is the sound world?
Okay, time's up. And I would like to thank our panelists that were this more than an hour here in Vilnius studio. That was Vytautas Landsbergis, the head of state of the re-established independent of Lithuania, Valdis Zatlers, former president of Latvia, and Sebastian Kaleta, secretary of state at the Ministry of Justice of Poland. And now you all have a half-hour coffee break. And I would like to welcome you strictly at 11, because you see the agenda, 5 minutes late at the end of the day. You are finishing not at 5, but at 6 or 7. You don't want that.
To host and moderate the second panel of today's discussion. When such a monstrosity happened in Ukraine, it's only human probably to ask why. We will probably never know the answer to this question, but our very honorable and distinguished panel of today will attempt to explain how. What are the legal, historical narratives surrounding the justification of aggression? We will look into the current infamous speech of President Putin, and we'll also look at the Putin's doctrine and broader historical legal constellations around this. So without further ado, I would like to introduce you the panelists of today. And I will start from Professor Lori Malkso, a professor of international law at the University of Tartu, and author of numerous leading monographs, including The Illegal Annexation of State Continuity, that discusses the case of annexation of the Baltic states by the USSR, including also Russian approaches to international law, Russia and European Court of Human Rights. Recently, Professor Malkso was elected member of the Council of Europe's Venice Commission, and he's also a member of the Permanent Court of Arbitration. Professor Malkso is an expert in history and theory of international law and human rights, particularly in Russia and former Soviet Union. Another panelist of today is Associate Professor Aurimas Švedas, a cultural historian, writer, creator of radio and television programs, Deputy Director of the Lithuanian Institute of History. He's an expert in Soviet history, politics, cultural remembrance, theory, and philosophy of history. Nerijus Šepetys is an associate professor at the Vilnius University at the Faculty of History. He's an historian, editor, and translator. His research interests focus on historical memory, analysis of the phenomenon of Nazism and communism, also crimes against humanity conducted during the Second World War. And finally, Assistant Professor Filip Svincik, socio-legal scholar, PhD in law, Assistant Professor in law faculty at the University of Warsaw. His academic interests focus on constitutionalism, the relationship between law and group identity, conflict resolution policy, legal regulation of collective memory, among other things. So I'm very, very glad to welcome you here all today. And I would like to start with Associate Professor Nerijus Šepetys to talk about more recent events, about the infamous Putin speech that explained the causes and the arguments behind aggression. So the floor is yours. 10 minutes.
Kalbėsiu lietuviškai. Kodėl, kaip sakė profesorius Tautas Landsbergis, profesoriaus Putino karo ryto, faktinė karo paskelbimo kalba tokia yra svarbi. Tai yra iš tokių tekstų, tokių šaltinių, kurie yra ne šiaip. Ne tik grasina, projektuoja ateitį, pučia propagandinę miglą, bet ir šitą pasako lūžinėse situacijose.
Very sorry for the technical difficulties. We will resume in a minute or so. Can you hear anything at the moment?
Can you hear interpretation?
Or
can you hear interpretation?
Okay.
Yes.
We can proceed. Sorry.
Kodėl Vladimiro Putino
Why?
Vasario 24
The speech of the 24th of February by Vladimir Putin is so important. And what makes it so special from other speeches, which are just threatening or trying to forecast the future, or by pulling the wool, the propagandic wool, this speech told us something in the breaking point when we have the lies which start to crack at their seals, and the lies have to be covered up somehow. The lies have to cover up very important and fatal decisions and the actions which are going to radically change the state of play. We see or we witness not only the images that are meant for one audience, but we also see the ultimate thought of the authors, and which are connecting the understanding of the situation before and after the breakpoint. And this allows us to understand Russia, which is undergoing its major transformation. And therefore, I'm going to speak about, I'm going to share my reflections about the Putin's speech and about his ideological ground-setting ideas by Professor Putin. I'm going to also review the ideology of the Soviet law, and I'm going to focus on the object that was the target of the speech. The speech itself was rather dilettantic, not logical. It was not homogeneous stylistically. We can even see a number of authorships, and sometimes they lack unity. Part of the speech were about US, NATO, Ukraine, the Ukrainians, us, Russia, which were organized differently, both from the point of view of rhetorics and the message. Well, quite surprisingly, by listening to the speech, we somehow came to understand the turbo-totalization when the fiction suddenly puts behind all the facts of reality that could otherwise be very easily verified. And it is done under conditions at the time when the monopoly of disinformation by Putin has not yet been fully secured, and when the lack of thinking by the addressees was not yet ensured. Of course, after the sanctions have been introduced and after the mass public response, then the Putin's regime decided to ensure the monopoly of disinformation and the strengthening of non-thinking crowds by introducing the criminal liability for any mentioning of the war. This should have done much earlier on, before the war, and such statement should have been addressed not only to those who have already been long amidst the quagmire in this propagandic war, that we are being attacked, there are some Nazis fighting the Jewish Banderovцы or similar allegations. The statement or the proclamation of the military operation was constructed on the idea that Putin knows more, and that was addressed to the so-called normal Russians who are traveling all across the world, and they are following virtually, basically they are doing social networking, they're following their brands. And therefore, the war proclamation speech didn't ensure a preventive difference between the fiction and the distorted picture of what is taking place in Ukraine. Forgetting about tens of thousands of missing Russian soldiers, in order to prepare the public for the war. To prepare for the war that Putin made no reference to on the 24th of February, because this is a ban, a taboo. He was referring, well, we may then remember the war, which was basically initiated by two totalitarian states, which initially were quite on friendly terms, and later they decided to wage the war of aggression against each other in the bloodlands and the people who were there in the bloodlands. With Hitler's Germany and Stalin's Soviet Union, Putin's regime is being compared more often than not, and I believe the relationship of the origin is very important. Namely, the the origins of this statement at the outbreak of the war. The war that Putin is referring at least 10 times in his speech, and he called it the Great World War or the Big War of the Homeland. In order to legitimize the offensive against Poland, Adolf Hitler, in his speech in Reichstag on the 1st of September 1939, which is the date as the starting date of the Second World War, is a very relevant source of the origins of the war. Back then, in his speech, Führer didn't make a single reference to war. In his speech, he was using such words as Kampf and was referring to the German actions as defensive, not as offensive. In his speech, he made reference to the World War and the beginning of the quote. Russia and Germany in the World War were belligerent against each other, and they fell victims. And it shall never happen again. And it will never happen. And of course, the fact isn't absolutely correct, but the forecast is absolutely wrong. A structured speech by Hitler looked somewhat similar. There was some conspiracy of the enemies or some emanating threat from the territories. We as if tried to negotiate on everything, but we were they were making the fools of us and they were disparaging us. We simply had to resolve the issue of Danzig corridor and to reload our relationship with Poland through in the direction of pacification. And that's what we hear in Putin's speech. A couple of elements are missing here. First of all, Hitler managed to focus on one object, whereas currently Putin's followers don't know yet with whom or against whom they are not waging a war. Would it be Ukraine, the West, America, NATO, or who else? Secondly, it is not yet clear. In the speech by Putin, there was only a reference to me as myself, whereas in the most decisive points, Putin referred to that it was my decision to launch a military operation, and as if by not willing to demonstrate the force. So, unlike the German-speaking residents of Poland in 1939, the Ukrainian Russian speakers didn't come to streets or didn't show that they were really expecting to be saved from somebody. So the preparations for the war were done on an ideological front, but not on a practical front. There is yet a second and a much more vivid root of the origin, which leads to the note of the 17th of September 1939, which was sent by the Soviets, signed by Molotov, and was served onto the Polish envoy in Moscow. And I need to read it into the original. I'm going to read in... I apologize for all the speakers. Well, Poland has become a very good field for any possible uncertainties, and which may become as a source of threat to the Soviet Union. And by being neutral, the Soviet government may not stay neutral to the fact, as well as to the fact that the Ukrainian and Belarusian nations are left helpless. And the second quote would be, in view of such a state of play, the Soviet government decided to order its military forces to protect the citizens of the Western Belarus and Western Ukraine. So the text is very concise, and there is a very clear link. And the very fact of Poland, the reference was made on the 17th of September 1939, and exactly the same is being done by Putin in his current speech. Second, the fact of aggression is negated, and the Soviet Union referred to the fact that it was simply trying to take over the protection of the border, and that's exactly what Putin was referring. And the third, residents of certain territories are already our people. Last time these were Poles, whereas nowadays these are non-Ukrainians. Back then, Ukrainians and Belarusians welcomed the Stalin's offensive much more enthusiastically than the current-day Russian-speaking Ukrainians. The Soviets were trying to motivate a non-declared offensive against Poland by the so-called threat which was being faced by the Eastern Brotherly nations from Germany. And of course, this caused a number of conclusions, and after some diplomatic negotiations, the wording was reformulated. In 2029, we are no longer hearing a friend of National Socialism, but instead there is a decision to free Ukraine from that. For 5 times in his speech, Putin refers to Nazism in Ukraine, and 4 references adds the German original. Both are threatening to Russia and to the lands of the Russian. Of course, they are going to go to Crimea and to Donbass, just as they did during the times of the great national war of the homeland, and the Ukrainian nationalist hitmen were killed. So it is quite obvious that in the eyes of the speaker and in his mind, there are some things or events that somehow merge. And by the way, these events took place 80 years from now. Hitler and fascism or Nazism is already, from a analytical point of view, which is a way transforming into a quasi-religious relationship. Because Putin talked about victims or the sacrifice that our nation has paved on the altar of our victory against Nazism are sacred. And therefore, the empire of lies is what the United States are being called by Putin. And from here, we have hear about the goals of the special operation to protect the people who have been suffering from genocide for 5 years. And to this reason, we need to demilitarize and to denazify Ukraine. And if we hear more attentively, we may hear a copy of the goals which were formulated by Joseph Stalin in his address of the 3rd of July 1941, at the time of waging war against National Socialist Germany. That was not to be a simple war. That was the war, or the great war of homeland of the Soviet Russian against the Nazis. And the goal was not only to eliminate any danger, looming danger, but also to help all the European nations suffering from the oppression of fascism. So there were references to salvation. And there were many allies, including the German people, who were, and therefore the fantasy, which was nurtured at that time, and which bring to life over 1 million of defectation in the armed forces, was rather exceptional. Just as Stalin was prepared to go and free Germany, and his successor is trying to do the same now. And we want to prevent even major threats. And the way the relationship between the so-called against West, Putin is basically an idealistic. He is trying to put the words into the mouth of his opponents. Where do we can expect this mannerism of disparaging and undermining approach towards rather legitimate position of the free nations? Well, we can all find one simple answer to that. Just as Putin in his speech refers to some alleged intentions towards other nations, so are his goals for Ukraine, as if to protect the people from Ukraine, from a horrible regime of Kiev rather than Moscow, and to perform its denazification and demilitarization, and to put to justice to the International Tribunal. Thank you very much for your attention.
Thank you. President Putin's speech is but one example of his doctrine that shaped domestic and foreign policy for more than a decade. And more on that, Associate Professor Aurimas Švedas.
Dear participants of the conference, it's a great pleasure to join this very important event. I'm really grateful for that, and I would like to ask your permission to share with you some thoughts about so-called Putin's doctrine, also in Lithuanian language. So please use your these sophisticated machines. Aš neturiu galimybės išsamiau pristatyti putinizmo
no opportunity to explore the phenomena of Putinism more extensively, which brings together the ideas of Nikolai Berdiaev, Solovyov, Ivan Ilvin. I can't detail imperial sentiments or the postulates of Soviet ideology. I can say the Putin's doctrine goes along with the cult of Czechism and the elements of fascist ideology and practice. I will only share a couple of thoughts on the genesis and development of Putinism. I will speak about the elements which have helped Putin to shape out the doctrine. I believe it was extensively developed from 2004 to 2008, and it set the course for Russia for many decades. The analysts who watched Putin's activities for a long time kept repeating the president of Russia is like a mirror for different audiences. He reflects the image of a particular group. And my memory just brings me back to the title of Gessen's book, The Man Without a Face. When the Russian troops occupied Crimea, the analysts blamed us for inability to predict Putin's actions. They believed Putin was pragmatic, but in fact he was a representative of post-Soviet elite, and he did not care about wealth. So I can say it was an error in estimations. In my view, Putin's actions were based and are still based on consistent but atrocious ideology. It's like a reversal of Huntington's model. So how did the Putin's doctrine got developed? In 2004-2005, some began speaking about the need for ideology to support Putin's doctrine. So they started speaking about the energy superpower. The term energy superpower was coined by Putin himself. And right now, I'd like to say there's no need to explore the meaning of this term. Yet, very soon, the term disappeared from the public space. Yet, the military and academic sources of Russia started preparing for the war, and they said the war was likely in 2004. The statement about sovereign democracy was more complex. Vladislav Surkov, who was a member of the inner circle of Putin, pointed out some important statements. Russia is an autonomous, self-sufficient and unique international political entity. It has the right to adapt and modify its model of democratic functioning as it wishes. The manifesto of the model for this approach was the book by the Russian politician and businessman Yuriev. It postulates Russia's war against Western civilization. It outlines the program for the physical extermination of the population of Ukraine and the Baltic states. This book became quite trendy. It was discussed and read in posh cafes of Moscow. And according to rumors, even the people from the Putin's office read it. On the 3rd of April, RIA Novosti published the text of Sergeyev, What Russia Must Do in Ukraine. Texts don't impact public imagination. Cinema works much better. And the visualizations of the Putin's doctrine were just brilliantly developed by Nikita Mikhalkov. I'd like to note the movie 12. And Mikhalkov says it's the most important obligation is to serve the nation and the national idea. Well, when we hear such ideas, we say they are trivial and trite. Now I can say all those statements which we believe are foolish, they keep working and changing the Russian society. So what's the most important measure for the Russian Empire? Its strengths. How can we measure the strengths of the state? By the size of its territory and the paralyzing intimidation of its neighbors. Thirdly was the end of the borders of the Russian Empire. The answer, nowhere. Russia is like an ocean in high and low tides, and the new tide comes and it'll soak us in. What will happen to the countries and societies nearby when the Russian Empire is in high tide? They say such countries are just fertilizers and they will be put to good use. So what's the fundamental reference point for such empire and its people? And they say it's the past. The past must be preserved, and future winds must not be allowed to blow in. In fact, the Putin's ideology served only some 50 persons. And it seems the public is fond of such ideology. I believe today I should remind you of one more book. It's Gurjev's and Treisman's Spin Dictatorships. They say we can see a new form of dictatorship in Russia. It does not rely so much on fears, but it takes advantage of such satisfying ideas. Thank you very much.
Thank you, Professor Sviadas. One of the key features of Putin's doctrine is a very specific interpretation of international law, and in particular, international humanitarian law. And more on that, I would like to ask Professor Laurie Malkso.
Hi, can you hear me? Yeah. First of all, it's very nice to be here. I would like to thank the organizers, especially also my friend Dainius Žalimas, for inviting me to this panel. I will start with a quote. It's from 2013. It was printed in New York Times, and the quote went like this: "Whether we like it or not, law is the law. International law is the law, it must be obeyed." Do you know who said it? It was Vladimir Vladimirovich Putin. And the context was was the so-called red lines that President Obama of the United States had said the US would draw in the case of Syria, and then there was a possibility of US military action. He wanted to prevent that, and he used that line to actually successfully, if that contributed to this, to not make this happen. He drew attention to the fact that the United Nations Charter of 1945 is very restrictive in terms of permitting use of force, in terms of jus ad bellum. And yet, the same person in 2022 explains why Russia must start it. He also uses the concept of self-defense without even bothering to give any explanations or any facts for self-defense. And I want to make my short, probably slightly impressionistic presentation to be an interpretation of that. What explains that? The same man, obviously he knows what the UN Charter says. Let's not forget he was a law student at Leningrad State University. He studied international law. And then 10 years change, and his at least use of the UN Charter becomes completely different. I think if people from some other West European countries, or maybe countries from outside Europe, would look at today's conference, they would say that, well, this is a gathering of Russia's unfortunate neighbors. They are all smaller than Russia. They actually suffer from this Russia's neighborhood, and they try to gang up, referring to international law and justice. But we know since Thucydides what is the way of the world, that the strong take what they can and the weak suffer what they must. So what can be done about it? I'm referring to this classical argument of realism, that great powers, it's simply a fact of history. They claim themselves more rights throughout the history, and realists would say that nothing can be done about it. This is the way of the world. And I want to argue with this argument of realism in one sense. I think it's still allowed to cite Lev Tolstoy. He starts, as you know, obviously the famous starting sentence of Anna Karenina: all happy families are happy alike, but all unhappy families are unhappy differently. And I would like to borrow that thought and put it in this realism's great power context. I think that if and when great powers violate international law, they violate it, at least sometimes, for different reasons, for different purposes, which is also one starting answer to anyone comparing, for example, US in Iraq 2003 and then Russia in now against Ukraine. So what are these differences? What is the specific cause of unhappiness for the Russian family or for the Russian member in the international community? The previous panelists, the distinguished presidents from earlier times, they made references to the Soviet period, to earlier periods of Russia, which they have lived through, which they know from personal experience. And one of the debates in Moscow during Perestroika was about so-called legal nihilism, pravovoi nihilism. So it was the self-critique of Russian elites that the Soviet Union did not value law. It used law mainly as an instrument for political ends. In the courts there would be telephone justice, but also in foreign policy, international law was really, for a country that never wanted to really participate, for example, in international court proceedings, international law is something what the political leaders say, and they can really say anything, as you are a great power with nuclear weapons and sitting in the Security Council of the United Nations. So they talked about it in terms of Russian constitutionalism, about this legal nihilism as a problem. But I think borrowed from the Soviet period and Soviet performance, this legal nihilism probably influences the use of international law rhetoric as well. Because in the end, what is it but legal nihilism if the same president is basically completely switching the position about the importance of the UN Charter in one context, highlighting it, in some other context basically violating it in the most brutal ways. It is really the idea that international practice is based on interest primarily, and law is really a fig leaf. You use these concepts to justify yourself. You say one thing in one context, another thing in another context. But it also reflects the kind of low value of law, which those Perestroika era legal thinkers criticized in the context of Russian society. And this is an old trope, if you want, in Russia. I'm thinking about the Tsarist era's leading Russian international lawyer, Fyodor Fyodorovich Martens, how he introduces his textbook of international law by saying that the country's approach to international law is shaped by the way they treat individuals at home. 1882, he says that. Nothing has changed. So that's why the question of human rights, the question of democracy continues to be relevant for the country's international legal performance as well. Now, we should also not forget that the present generation of leadership, like Putin and Lavrov in Russia, they all grew up and were formed as persons at the time of Cold War antagonism. This antagonism also found its reflection in international law. If you take a random Soviet textbook or I don't know, Soviet yearbook of international law from the, let's say, early 1980s, you would quickly see in which ways international law is presented as a field of struggle. And there is this argument that socialist states, of course, understand international law differently, more progressively than the capitalist ones who understand it wrongly. So this is an integral part of this international law discourse. And in different periods of the existence of Soviet Russia and Soviet Union, there is even a denial of universal international law. The first Soviet author, Korovin, in the 1920s, writing about international law, denies that there could be universal international law, because why would a socialist country want to maintain all those capitalist rules with those other countries. My argument is that this did not go away. In the 1990s, it seemed that there was a possibility for this going away, with Russia joining the Council of Europe, with adopting basically liberal style of constitution, even though strongly presidential, in 1993. But this antagonism is basically transformed, and it is transformed into civilizational rhetoric. Instead of capitalist countries hating socialist countries, now it is about the West hating Russia, the West encircling Russia, undermining Russia, and therefore, you know, for civilizational reasons, Russia has a different, you know, understanding, different mission. It's never, you know, purely legal ideas. These are basically partly religious ideas, theological ideas of Russia's mission in the world. And I spent several years reading as many Russian texts on international law as I could. I could clearly see this rise of civilizational rhetoric and basically replacing this Cold War era capitalism versus socialism. The next jump, I think if we are, and maybe the last thought, because I know the time is running out, I think Russia is not simply a big state, big territorial state or great power, but it has maintained elements of empire. Yes, the Soviet Union disintegrated, collapsed in 1991, but the imperial problem to some extent remained. The idea then was that no one who used to be part of the Russian Federation had the right to secede from Russia. But you had, of course, this question in places like Chechnya, who for a while also you know, expressed different kind of wishes. I think because this tragedy of Russia in the last 10 years has really been, it has been a political one in the sense that Russia has not known how to become a normal nation state. It found nothing else for its identity but resort to the imperial identity. And because of that imperial identity, Russia doesn't know where its borders are. We see it in Belarus. Russia cannot treat Belarus as a sovereign country, and we see it in Ukraine, where it now has basically resorted to land grab, saying that if you Ukrainians, you know, want to turn your back to us, then at least we'll take the certain lands away from you. And I think this is something, and this is my message to colleagues in the West. All progressive people in the West, they have condemned Western imperialism. It would be very much not en vogue for someone to argue today that, I don't know, Algeria is sort of France. And it was easier to do because there is this element of, you know, Western empires being overseas, outre-mer. It's obvious, and then the issues of, I don't know, different ethnicities and even race come to play. Now, from the perspective of these nations which you're now visiting, or where this conference is taking place, the Russian imperialism doesn't have to be about race. If you, referring to the same Martens in the 19th century, who was actually originating from Estonia, he's also very strongly arguing as a Russian imperialist. Should always keep that in mind. And I think there is a certain weakness in the Western left, in particular for the Soviet Union. Maybe it was some sort of anti-capitalist utopia, and maybe we should defend some of its legacy. But I think from the perspective of those nations who experienced Russian imperialism, it was also a very successful way of extending that imperialism, making it not disappear like it happened for the Western empires in the 1950s and 60s, but formally only disappear in 91, and now we are maybe seeing a research or resurgence of this imperialism, because how else to call what is happening in Ukraine? Thank you.
Professor. Thank you very much. I actually have one brief anecdote to share. It's just going to take a minute. Right before the pandemic hit, I had a chance to visit Moscow, and we were at the National History Museum. And there was a school trip organized with school children of about 8, 10 years age. And their teacher was talking to them, showing the map of Europe, and showing Finland in particular, and saying, look, this used to be ours. You didn't need to get a visa in order to go to Finland. I hope this will end soon, and we will all be able to travel again, and this will all be Russia again. So memory is also used and abused just like international law. And more on that, I would like to invite Assistant Professor Filip Tsiunsky to tell how memory is also being instrumentalized in order to legitimize Russian aggressive behavior.
Thank you very much. It is a great pleasure to be here in Vilnius with all such distinguished scholars, even people who were my professors in the past, like Professor Malsko. So now we can have something like intergeneration dialogue. I would like to also particularly thank you for Professor Dainos Žalimas for the invitation. And at once, it's easy and difficult to be the last in the panel, because after these 3 speeches, I will try to link all these elements which were already put on the table. So the element of the memory of the fact and the Putin speech, and also the first thing which came to my mind when I was trying to design this 10 minutes presentation was, of course, Putin's presentation. But from the other side, also mentioned today, the Stalin's speech in July 1941, and the way how he was using the narratives. As far as I remember, in Stalin's speech, there was no even one ideological reference. Brothers and sisters, the second great motherland war. And I think it's a key to maybe to not understand, because for us as Westerners, it could be confusing, but to start analyzing some legal elements of some legal memory policies in the East and in Central Europe and in the West. So the Putin speech was a key. I totally agree that there was nothing about the facts. It was all about the emotions, or something what we can try to name in the quotations like social facts which are existing in Russia. And I remember, and it is my experience, and I will now use the anecdote as an argument, when I was in Tartu doing my Erasmus and I met Russian students. And they showed me the Russian history handbook with Polish pre-war borders. Unfortunately, the Polish eastern border was similar to the Ribbentrop-Molotov Pact border. There was nothing about Eastern Poland, pre-war Eastern Poland. So this is the element which is quite present in these legal memory policies, because law, since the beginning of the politics of nationalism, law has always played some secondary role to the political decision how we are designing our commemorizing, how we are designing the way of collective memory, the collective memory as a social construct. Of course, the way how it's not a time and there is no space for the discussion about the process of collective memory creation, but we have to remember it's more about co-remembering and the presentist interpretation of the events from the past than talking about the historical facts. So this, what President Žalters mentioned also during the previous panel, it was the typical example of Russian backslash. Of course, Russia was probably the only one communist country, maybe next to the Belarus, which has never condemned the communist past systematically. They never used the condemning the communist past for the reconstitutionalization or the source of the constitutionalization of the democratic Russia. They were even in of course, today's situation is incomparable with the 90s. But today we see the big backslash, and also the Russian director Nikita Mikhalkov was mentioned today. If we compare first part of Burned by the Sun and the 2 sequels, we see this backslash, memory backslash in Russia. Also, but Burned by the Sun is very significant for me. Also, these elements of connecting the empire and the Russian identity. And of course, the law was in use in a very classic way. When in Central Europe, when in Western Europe, now the very interesting processes are appearing in Spain, where they are on the process of the adoption of new memory law. The law on democratic memory, which they tried the law to remember, right to remember as an element of human rights catalog.
the Spanish socialist government of Pedro Sanchez. Now they are proceeding this act. Russia stayed in this classic 19th century politics of nationalism. And the law still plays secondary role. And this Putin's backslash, this political decision about the backsliding from the condemning the communists to the attempt to create some strange, even for Central Europeans, or confusing narrative system, where the Tsar Nikolaus II can stand next to the Stalin and nobody is confused and everybody can explain it, creates new space. But we have, in my opinion, we have to look at law and the legal memory policies of Russia from the perspective that they never made this shift which happened in 20th century or in 90s in Western Europe or in 90s in Central Europe regarding the memory. So there was no this space for reconstitutionalization by condemning the communists systematically, as Professor Malsko said. Of course, this Russian constitution of 1993 at first glance was liberal with strong president constitution. But from the other side, there was no this element of, I think, legitimacy. 1993 is also shooting to the parliament on president's order in Moscow. And now the question is how the law was used. As I already said, it was like a traditional proceeding of secondary role of law. The scholars studying the memory policies, the collective memory, usually use this trinity of monuments, public secular ceremonies, and school, the history lessons at school. And if we look at Russia today, we cannot say that there is something different. What could be confusing us is this narrative, what is written in these narratives. One of the scholars studying, one of the most distinguished scholars in the past studying the nationalism, Ernst Gellner, in his book, The Nations and Nationalism, used the analogy of a man who lost his shadow, that the identity is like a shadow. This man lost his shadow, and he was normally functioning, but people were trying to avoid him. He was losing the friends. And to sum up my today's little short intervention about these elements of memory, Russia, and the legitimizing the aggression, what is interesting in Russia is the fact that they are not losing their shadows. They've never lost their shadow, but they are able to change this shadow like a suit. These narratives are very flexible, and the law is used as a secondary source and adoptive. Last days, and the Lavrov speech, we can, by paraphrasing Marx, on Jewish question. It is once again very flexible and very confusing for the democratic societies use of some very simple codes or very simple narratives. Actually, they know what are they doing because they are referring to this very people's anti-Semitism, historical, like in The Fiddler on the Roof. The Fiddler on the Roof is not about only Teva the mill maker, the mill seller, but also about the parallel society which exists in Tanayevka. And same, they are making these references. And now the question, can we, I will do it in the reference to the President Jalter's speech once again, because the question is, are we able to change this mentality, or are we able to change this mechanism of instrumentalizing the memory, instrumentalizing the law, instrumentalizing the memory law without in-depth change of Russian society? Of course, they can create the democratic community. They can adopt liberal constitution. And now my argument maybe will not be super academic because it's not a time for the in-depth research. The war is going on. But I've read 2 interviews at the beginning of the war with Russian dissidents who are now the residents of Poland. Of course, they were condemning Putin. But from the other side, one of them said that she will never go to the protest anymore, to the Ukrainian protests in front of the Russian embassy, because Ukrainians are shouting death for the enemies. And she's not accepting that because her partial origins are somewhere next to the Kiev, and it's a brotherhood nation, and the Gogol was amazed by the Dnieper River, and so on and so on and so on. Another interview 1 month later, another Russian dissident academic let's leave the name. The narratives are the most important. When it was pretty obvious that the Russians will not be able to capture Kiev, that they will not close the siege, he started to talking about that, of course, but one of the conditions of the peace should be not humiliating Russia, not humiliating Russian proud. And just to sum up, I will use another quotation from Taras Bulba, which was written in one of the walls in Ukrainian cities. When Ukrainian forces recaptured one of the cities next to the Kiev, they read on one of the walls the quotation from Taras Bulba written by Russian soldiers probably. Well, so how did your polls help you? And this is like a final point. So the big question is, of course, the law, memory loss, this shift in which is happening in the West, but it is not it has never happened in Russia. And I will leave it like as an open question for the discussion. Is it even possible in near future in Russia? Thank you very much.
Thank you very much. Because we're almost out of time, I'd like to abuse my position as a moderator and actually continue on the note that you were following. The topic that kept on reoccurring throughout the discussion was the Russian civilizational distinctness from the West. This is the rhetorics they themselves use. This is the rhetorics that we in the West keep on using. And this will definitely shape the international order and the international legal order in the future. Do you think we have any tools and techniques to address this challenge? Anyone care to?
Well, one, if we speak in the context of international law, then civilization, of course, is a problematic concept because in the past of international law, European powers, including Russia, use the so-called civilizational standard against the others, saying that international law only belongs to Western, Christian, civilized countries. So in that sense, this concept is contaminated in the history of international law, and also I don't see many people in the West using that in the context of international law. However, there is one interesting thing. There's one interesting thing I want to challenge international lawyers. We have some very distinct international lawyers in this room. By Huntington. Huntington writes in his Clash of Civilizations that the Western answer to civilizational plurality in the world is universality. So in other words, the West has taken the norms that it likes and says that no, these are all universal. Let's not have a debate about that. And I think in civilizations, I think there is silently an assumption that China is different than Europe. I think who would really deny that or argue that? We can have universality of international law, but I think in culture, in history, obviously there are many things in China that are different. Now, what makes this Russian case interesting and problematic is this on and off relationship with Europe. In certain time periods, wanting to be part of Europe and then saying that, oh, we hate it, that is not us. Like Nikolai Danilevsky in the 19th century saying that Russia and Europe, these are two opposites. By the way, an interesting fact, nowadays with this propaganda background, when the majority of Russians are asked, they don't say they feel European. The majority of the Russian people nowadays, according to polls, say they don't identify with Europe, which also must be, taken into account.
Okay, the question regarding the memory, and it was already mentioned by Professor Malsko that they don't feel European. But the other problem for me is this not belonging to the even European interpretation of the past or European interpretation of the memory. What was done even by Germans in 70s, the Frankfurt trials. In Russia, we have still, analyzing Russian narratives, we can still see that they have their own Great Motherland War or the Second Great Motherland War, but it was, even in the Soviet period, quite anti-West and quite anti-Western. So the problem is quite significant. And
Honestly speaking, I have no answer to this question because the difference is so deep at the moment, and the processes and the way how they are trying to protect them. They just after the beginning of the war, they shut down the memorial. Also the adoption of law was quite, this 15 years imprisonment law was quite important. But the problem, I think, is quite global. That's why I very liked the question about the legitimacy of the tribunal in terms of some co-memorizing or co-remembering and some codes of imperials and putting one empire against the other. So I will not add only China to the question on legitimacy of the tribunal. I would also add Latin America, for example. And it's also the experience after the beginning of the war against Ukraine, when the Latin American socio-legal scholars were against any letter condemning the Russian aggression, because Russia is protecting the Europe from gringo imperialism, gringo American imperialism. So those are gringos, the gringos delivered Ukrainians weapons, so Russia is protecting, but where they work? They're still working at the level of the collective memory about the Soviet Union. And the Soviet Union as a prophet of the nations, particularly in Latin America. So the question about the legitimacy should be also applied to this question of feeling of belonging.
Thank you so much for an honest answer. For an academic to say, I don't know, is a completely normal thing. And I'm very glad you said so. And we'll leave this question open for the following panels to discuss. Thank you all very much and have a nice discussions in the afternoon.
Schedule, and I think I'm still missing, yes, here you are. And I think we start this afternoon, the started afternoon is devoted for the legal aspects that we have in relation to the different legal forums that might be there for the prosecution of responsible. And I would like to give introductory comments for our online participant, and that is Minister of Justice of Ukraine, Mr. Maluska, to open the panel. So, dear Minister, you can take the floor.
Thank you. Do you hear me well? Is everything okay? Okay, fine. So thank you for the opportunity to participate during this important event, during difficult times for Ukraine, and during the war and its consequences we are experiencing right now. For our country, it is really crucially important to ensure that those people who are guilty, and I'm talking about Putin and his biggest allies within the Russia and the top management of the Russian Federation, they will and shall be brought to the court. There shall be a trial, and they shall feel the consequences, legal consequences of the actions they did. We have several limitations related to how this could happen, and I'm pretty sure that you've already discussed and will discuss during this event what are the bottlenecks, what are the problems related to bringing justice to Ukraine and to to and bring to responsibility those who committed international crimes, in particular crime of aggression. And the natural problem with the International Criminal Court here is that it doesn't have jurisdiction of the crime of aggression just because Russian Federation didn't ratify the Rome Statute. If our ratification could help with that, we would do that immediately and easily. But given that ratification of the Rome Statute by Ukraine won't help us to add jurisdiction over the crime of aggression to the jurisdiction of International Criminal Court, well, we still are in progress of our efforts to ensure proper implementation of the Rome Statute in Ukraine. We started several initiatives related to domestication of the Rome Statute. The draft law is in the parliament, and we also, the parliament recently adopted the law governing cooperation of Ukrainian enforcement agencies with International Criminal Court, which would help to investigate war crimes, crimes against humanity committed on the territory of Ukraine. On the other hand, another natural option to investigate and punish those responsible for the crime of aggression would be a creation of a separate tribunal tasked with the goal to ensure proper trial, proper investigation, and judgment over those who started the war. Again, most probably we will have a problem with that, not with the trial, not with the evidence, since we have abundance of evidence. And Russia really did not reject that they started what they call special military operation, but what is naturally an aggression, an act of aggression. And again, we feel the support of international community here. But what the problem would be enforcement of such a judgment, since naturally Putin or his team won't come to Kiev, to Hague, or whatever the seat of this tribunal will be. And naturally, until regime changed in Russian Federation, or until Russia is defeated in the war, we won't be able to enforce such a judgment, and that adds the necessity of other actions, not only limited to criminal trial. And here I'm talking about other possible consequences of the recognition of Russia as an aggressor and recognition of the crime of aggression committed by Russian officials. And here I'm talking about economic dimension of the consequences of the crime of aggression. More specifically, we as a country, and I'm sure not only we, but other countries and legal entities and businesses are interested in compensations, in reparations related to the damages committed by Russian Federation and their military forces on the territory of Ukraine and outside the territory of Ukraine in terms of consequences of economic sanctions imposed on Russia. We believe that the status of aggressor and commitment of a crime of aggression shall allow lifting sovereign immunity over assets of Russian Federation. And I'm talking here about sovereign immunity over assets of the Central Bank and Welfare Fund of the Russian Federation. Since those assets are now protected by sovereign immunity, we cannot claim them, we cannot use them as compensation for damages, but there shall be a framework developed leading to lifting sovereign immunity over those assets in the case the country, the owner of those assets, commits a crime of aggression. This is there is a natural reasoning behind that, since why European countries, US, UK, Canada, shall help Ukraine and Ukrainian people by their taxpayers' money if they have abundance of Russian money already frozen in those countries. So in that case, we would like to have and suggest adding the link between recognition of the crime of aggression to the economic consequences in terms of allowing us to seek compensations and repatriations from frozen Russian assets, assets of the central bank. So in that case, our people would feel that the judgment, the court ruling won't be left on a paper only, but there will be real consequences and real punishment to the state, to the Russian Federation as aggressor, and their management. Apart, of course, the usefulness of the message that Putin and his team are not presidents, not the president and not head of the military forces of a civilized nation, but war criminals, and no more than that. So I would stop here and leave up to you to discuss maybe some other opportunities and ways, and maybe to suggest something to us, how we shall behave, how we shall move forward with this and or other ideas. And I'm really grateful for the support provided by all international community, all our partners, all our neighbors, not only neighbors, but also countries in the same difficult situation, neighboring with Russia. Neighboring with Russia is a huge headache, and even in peaceful times. But during these times, it's a dangerous time, and we are on the same boat, and we shall deal with this problem together. Thank you.
Thank you, Minister. And I think we will have a chance to try to answer probably the issue raised by the Minister, whether we can link the aggression with the issue for compensation. And I would like to present the other distinguished panel that we have today, Professor Niels Blocher, who is Professor of International Institutional Law at Leiden University and has been previously Deputy Legal Advisor in the Dutch Ministry of Foreign Affairs. And in that capacity, he had a chance to represent the Netherlands during the negotiations on the crime of aggression from 2000 to 2010. So could you please give us a short overview at the crime of aggression, if we take it in the context against Ukraine, from the perspective of the long-term development in international law that happened in relation to the crime of aggression?
Thank you very much, Gabia. Thanks to the organizers, in particular the Ministry of Justice of Lithuania and the Law and Democracy Center. Indeed, my presentation will look at the crime of aggression against Ukraine from the perspective of the long-term development of this crime in international law. And my presentation will have a simple structure. First, I would like to look at the past, then at the present, and finally at the future. And I will try to keep it as brief as possible. So first, the past, very briefly. I think one of the achievements in international law since the end of the Second World War is that a permanent international criminal court has been established with jurisdiction over 4 crimes, including the crime of aggression. And this is a great achievement because, as was always mentioned during the negotiations of the crime of aggression is legally complex and politically sensitive. Let me briefly recall some of the building blocks that made this possible. Very briefly, the Nuremberg and Tokyo tribunals have already been referred to. The 1974 UN General Assembly definition of aggression, not the crime of aggression, but the act of aggression committed by states. Then the establishment and functioning of the Yugoslav and Rwanda tribunals in the 1990s, showing that it is feasible to bring to justice leaders who have committed the most serious international crimes. The functioning of these ad hoc tribunals provided a great boost for the establishment of the ICC in 1998. At the time, there was not yet agreement on the crime of aggression, but it was so obvious that there should be no ICC without jurisdiction over this supreme international crime that the statute covered this crime and made it clear that it would only be complete with effective jurisdiction over the crime of aggression. Between 2000 and 2010, intensive negotiations took place on the crime of aggression. Unexpectedly, completely unexpectedly, agreement was reached in 2010 during the ICC review conference in Kampala, and the Kampala amendments entered into force almost 4 years ago, 17 July 2018. At present, 123 states are parties to the ICC statute. 43 of them, including Lithuania, have also ratified the Kampala amendments on the crime of aggression. Of the 5 permanent members of the Security Council, only France and the UK are parties to the ICC statute, but they have not yet ratified the Kampala amendments on the crime of aggression. So there is now a permanent international criminal court with jurisdiction over the crime of aggression, and this is no mean achievement. The next step is to make it more effective. More states should ratify the Kampala amendments, and of course, more states should join the ICC. However, even though it is an achievement that there is now a permanent international criminal court with jurisdiction over the crime of aggression, the scope of the ICC's jurisdiction over this crime is more limited than its jurisdiction over the other 3 crimes. When we analyze the details of the Kampala crime of aggression amendments, this confirms that we are dealing with something that is legally complex and politically sensitive. There are 2 key issues: the definition of the crime of aggression and the conditions for the exercise of jurisdiction. Legally complex is particularly true for the definition, politically sensitive, particularly true for the conditions for the exercise of jurisdiction. Briefly, first on the definition. There was already provisional agreement over a definition before the Kampala conference, and this definition has 4 elements. First, decriminalized conduct is the planning, preparation, initiation, or execution of an act of aggression, and this was much inspired by the Nuremberg and Tokyo definitions of crimes against peace. Secondly, the perpetrator. The perpetrator is a leader, or defined in the Kampala agreement, a person effectively to exercise control over or to direct the political or military action of a state. Third, the act of aggression by a state is defined in Article 8. This definition uses the 1974 definition of the General Assembly. And finally, the 4th element of the definition is the so-called threshold. Not any act of aggression is covered by this definition. It is required that the act of aggression concerned by its character, gravity and scale constitutes a manifest violation of the Charter of the United Nations. So these are the 4 elements of the definition that has been adopted in Kampala. Secondly, the conditions for the exercise of jurisdiction. Agreement could be reached on these conditions only during the Kampala conference, completely unexpected. The extremely difficult negotiations on these conditions had to find a compromise between 5 states and almost all other states, and you will immediately understand who these 5 states are. In the negotiations, they took the view that the ICC should only exercise jurisdiction over the crime of aggression after the Security Council had first determined that there had been an act of aggression by the state concerned. In this way, they wanted to extend the exceptionalism of their superpower position in the Security Council to the exercise of crime of aggression jurisdiction by the ICC. For the overwhelming majority of other states, this was unacceptable. International criminal law should apply to all, No one should be above the law. So much about the past. But let me add just a few words finally about the Kampala agreement. The Kampala agreement is indeed a compromise. And key characteristics of the Kampala agreement are that there is a distinction between, on the one hand, jurisdiction triggered by a state referral or proprio motu by the prosecutor, and on the other hand, jurisdiction triggered by the Security Council. The 5 veto powers can control the Security Council trigger by using their veto if a resolution is proposed to refer a situation to the ICC. But they cannot veto the exercise of crime of aggression jurisdiction if this is triggered by a state or by the prosecutor. However, in these cases, the exercise of jurisdiction of the ICC is more limited than the exercise of jurisdiction over the other 3 statute crimes. In particular, state parties may opt out by declaring that they do not accept crime of aggression jurisdiction by the court. And so far, 2 states have done this, namely Kenya and Guatemala. Secondly, the court shall not exercise crime of aggression jurisdiction in respect of a non-state party when committed by its nationals or on its territory, and that is essential here. Third, if there is no Security Council determination that an act of aggression has occurred, the prosecutor may only proceed with an investigation in respect of a crime of aggression if the ICC's pre-trial division has authorized the commencement of the investigation. It is therefore not excluded that the court will exercise jurisdiction over crimes of aggression committed by leaders of one of the 5 permanent members of the Security Council. But this is almost impossible with regard to permanent members that are not parties to the Rome Statute. In Kampala in 2010, it was decided that the adopted crime of aggression amendments would be reviewed 7 years after their entry into force. This is in 2025. It may not seem likely now that the scope of the court's aggression jurisdiction will then be broadened in some way, or that it would be accepted that not only the Security Council but also the General Assembly or the International Court of Justice could predetermine the existence of an act of aggression. But this would not be the first time in the history of the ICC that the unexpected would happen. In the early 1990s, many did not believe that it would be possible at all to establish an ICC. In 1998, after the Rome Conference, no one expected that the statute would enter into force in less than 4 years. Not many expected that the Security Council would already in 2005 refer a situation to the court. And before the Kampala Review Conference, no one expected that there would be an agreement on the crime of aggression. Sometimes the impossible is possible. Let me now very briefly go to the present. On this very long road, this very long international law road towards individual criminal liability for the crime of aggression, where are we now? We have come a long way in the past couple of decades, but there is still a long way to go. And this is clear if we now apply the existing crime of aggression rules to the aggression against Ukraine. First, the word aggression has often been used in this context, but this has mostly been done in a political sense, not in an international criminal law sense. It has been used in a political sense in the draft resolution presented to the Security Council that was vetoed by the Russian Federation. Likewise, in the General Assembly resolution adopted on the 1st of March, carrying the title Aggression against Ukraine, and also in the resolution adopted by the Human Rights Council on the 4th of March, and also by other international organizations like the ILO, the World Tourism Organization, the Council of Europe, CERN, and there are others as well. The ICJ in its order of 16 March has not used the term of aggression. And as you know, the case before the ICJ is limited to the interpretation and the application of the Genocide Convention. Now, if we look at the definition of the crime of aggression in the ICC statute, it will be difficult to conclude that crimes of aggression have not been committed by Russian leaders against Ukraine. It is clear that there has been planning, preparation, initiation, or execution of this invasion. The alleged perpetrators are the political and military leaders of the Russian Federation. The invasion is an act of aggression by Russia. The only element on which there may be some discussion is the threshold. Did the invasion constitute, by its character, gravity, and scale, a manifest violation of the Charter of the United Nations? In my view, at least, this requirement is fulfilled. However, while this may seem rather obvious, it is unlikely for the time being that the ICC will convict individuals, leaders, for having committed crimes of aggression. Neither Russia nor Ukraine is a party to the ICC statute and to the Kampala amendments. The Ukraine declarations accepting the jurisdiction of the court do not cover aggression, and the Security Council is unlikely to refer the situation in Ukraine to the ICC. So it must be concluded that the ICC will not be able to exercise jurisdiction over crimes of aggression committed in Ukraine as long as Russia is not a party to the ICC statute or has accepted the ICC's jurisdiction. Finally then, some words about the future. Against this background of the long-term development of the crime of aggression and the present near impossibility to prosecute the alleged crime of aggression against Ukraine before the ICC, is there anything else that can be done? Or should the conclusion be that the present reality is that there can be no crime of aggression prosecutions for the invasion of Ukraine? In other words, is there aggression impunity for Putin and other political military leaders of Russia? In short, is there imputiny? When answering these questions, we need to carefully sail between the realism of Scylla and the idealism of Charybdis. The Russian invasion of Ukraine has been strongly condemned by many countries. The flagrant violation by Russia of the jus ad bellum has activated all available parts of the post-war order, established to save future generations from the scourge of war. Post-war machinery was built to prevent such violations and deal with them when they occur nevertheless. Since the invasion of Ukraine, we have seen how this machinery has reacted. We have also seen its inherent limitations, such as the veto in the Security Council, the limited jurisdiction of the International Court of Justice, and the lack of aggression jurisdiction of the ICC. The outrage over the deficiencies of the current order to address the Russian invasion and protect Ukraine has triggered a number of measures and initiatives, sanctions by states and international organizations, expulsion from the Council of Europe, suspension of cooperation with Russia by a number of international organizations. It has also triggered a proposal to establish an ad hoc tribunal to deal with the problem of imputiny. In my view, such a tribunal would be a second-best solution. At the same time, it is true that international relations are full of second-best solutions. As has been said in Dutch politics, if things cannot be done in the way they should be done in the way they can be done. The argument is, of course, that the second-best solution is better than no solution at all. However, in order to be truly a solution, even if second best, and not merely a paper tiger, and the Justice Minister from Ukraine has referred to paper in his presentation, a number of preconditions must be fulfilled. Ukraine deserves nothing less. The proposal by lawyers, politicians, and others for an ad hoc tribunal presented early March by this panel at Chatham House will be fully discussed this afternoon, and let me therefore only make a very limited number of staccato observations. First, I think it is mistaken to compare the proposed Ukraine Aggression Tribunal to the Nuremberg and Tokyo tribunals. The war in Ukraine is not the Second World War. Russia is not Germany or Japan. Putin is not Hitler. At the end of the Ukraine war, Ukraine will not have occupied Russia with an imposed victors' tribunal trying Russian leaders. Secondly, an ad hoc tribunal should not be established in isolation, but should be part of an overall strategy to end the war in Ukraine and to prepare for long-term peace. Thirdly, an ad hoc tribunal cannot be fully self-standing. It needs a solid foundation, as well as a sufficiently strong political and financial backing. In order to be legitimate, it needs a governance context that meets the requirements of international criminal justice. Otherwise, it would not be rule of law, as we say, but it would be rule by law. And this distinction has often been made. This also provides some guarantees that lessons learned from, I would propose that one way to do this, so that this tribunal would meet the requirements of international criminal justice, is to involve the United Nations. And this also provides some guarantees that lessons learned from previous ad hoc criminal tribunals are taken into account. The UN could be a party to the treaty establishing the tribunal, and the General Assembly could approve or endorse it. This has been done before, although a key difference is that in the cases of Cambodia and Sierra Leone, the governments cooperated. In this case, Ukraine may cooperate, but the target state, Russia, is unlikely to cooperate without regime change. And this raises the question of the usefulness of in absentia proceedings. Leaving this aside, the UN framework, in my view, is better than bringing the tribunal under the umbrella of the Council of Europe, that has just expelled Russia and located in Strasbourg. The global outrage has illustrated that the aggression by Russia against Ukraine is of universal concern. The tribunal should be located near the ICC, International Criminal Law, and near the ICJ, jus ad bellum, as there are more synergies with these courts than with the European Court of Human Rights in Strasbourg. It should be composed of the most eminent crime of aggression and jus ad bellum authorities with relevant experience. Fourth and final, an ad hoc tribunal should be created in such a way that the great problem of selectivity or double standards is kept as small as possible. 4 brief comments on selectivity. First of all, international criminal law is unfortunately more selectively enforced than domestic law. But that should not be taken as a given, rather as something that should be rectified as much as possible. Secondly, the selectivity problem should not be overstated in this case. Since 1945, there have only been a limited number of outright invasions, similar to the current one in Ukraine. The invasion in Ukraine is rather exceptional, and such an exceptional case of aggression justifies an exceptional reaction in the form of an ad hoc tribunal to pursue individual criminal accountability. Third, this is only the second major war in Europe since 1945, after the one in former Yugoslavia. And in that case, an ad hoc tribunal was created as well. Finally, the main double standards problem could be that some states that want to create or support the ad hoc tribunal have not submitted themselves to the crime of aggression jurisdiction of the ICC, or to the ICC at all. Do not do to others what you don't want to be done to you. In other words, practice what you preach. If the General Assembly would approve the establishment of the tribunal, it should also recommend to states to join the ICC and ratify the Kampala amendments. In conclusion, there are good reasons to focus not only on war crimes, crimes against humanity and genocide, but also on the crime of aggression in the context of the war in Ukraine. It is therefore excellent that this conference is organized. The aggression against Ukraine, the invasion by Russia, is after all the primary evil. Serious international crimes have followed, but would not have occurred without the prior aggression. This is why the Nuremberg Tribunal referred to this crime as the supreme international crime, and why the UN General Assembly in 1950 stated that this is the gravest of all crimes against peace and security throughout the world. In the near future, the ICC will not be able to exercise jurisdiction over crimes of aggression committed against Ukraine. A second best solution is to establish an ad hoc tribunal for aggression against Ukraine. But this should only be done if a number of preconditions are fulfilled. If this is not the case, it would be better not to establish an ad hoc tribunal, but as a fallback option to concentrate on investigative mechanisms. If the preconditions are fulfilled, an ad hoc tribunal might be useful as a second best instrument against imputiny for aggression against Ukraine, although expectations should be managed. It could also contribute to the long-term project of individual criminal accountability for aggression, so that if ever in the future aggression will occur again, the ICC would have jurisdiction as a first best solution. Thank you very much.
Thank you, Professor. And as Minister and Professor talked about International Criminal Court and is there legal gap for the Special Tribunal that might be there, I would like to present the other panelist that we have today, and this is Ms. Oksana Zolotaryova. She is Director of the Directorate General of International Law of Ukraine's Foreign Ministry. And I would like to ask you about the other legal formats, other legal proceedings that Ukraine is already using in the context of aggression against Ukraine.
Thank you. And first of all, let me start with saying huge thanks to the Ministry of Justice of Lithuania for organizing such a very important event and joining so many prominent people in one offline event that we have been missing for a couple of years a lot. And also, I would also like to thank the people of Lithuania for supporting Ukraine, for their support and for their help throughout the whole our history, but especially in this last couple of months. Really, since 2014, when Russia started its brutal aggression against Ukraine, we understood that justice should be brought to the people of Ukraine. And at that very moment, we understood that, unfortunately, the processes won't be very fast. And we tried to use all possible legal forums and mechanisms to bring Russia to accountability, but 8 years have passed, and unfortunately, we still are not able to go to the merits phases of different kinds of proceedings that we have launched. ICJ has very limited jurisdiction, and we cannot just go and discuss all core issues with the Russian Federation, the ICJ. We proposed Russian Federation since 2014, let's go to the court and solve all the questions we have there. And we have been proposing this to Russian Federation a couple of more times. The answer was no. If we can negotiate bilaterally. But that's the not issue of bilateral negotiations, the violation of international law. Each violation of international law, and of course of internal law as well, it should have the proper legal answer. And Ukraine and the Ministry of Foreign Affairs initiated a number of cases where there is, under the conventions, the possibility of referring the cases to the ICJ. And we see now that there are a lot of conventions, but all of them has compromissory clause, a lot of them, that have no possibility to bring the countries that are violating them really to justice. We understand that it is the compromise between big countries while negotiating the conventions. But maybe the situation now, what we have in Ukraine, is the turning point that will make in future international law really effective and operational mechanisms and conventions to which countries sign and ratify. They have very quick means to be brought to accountability for those who violate them. So we launched a case against the Russian Federation in the International Court of Justice on application and interpretation of two conventions, on terrorism financing convention and on racial discrimination conventions. We negotiated with Russia 11 rounds of talks before going to ICJ, as this is the precondition under the both conventions. And actually, Ukraine is the first country who ever brought a case under the Terrorism Financing Convention. And Ukraine also is the first country who managed to win jurisdiction under the Racial Discrimination Convention. Our case concerns that terrorism financing on Donbass. We say that the Russian Federation provided weapons, ammunition, funds to DPR, and these funds were used by DPR to create terroristic attacks. Mainly it is MH17, attack on Mariupol, attack on Kramatorsk, attack on Volnovakha back in 2015, and also bombing of Avdiivka, and having terrorist attacks in Kharkiv. The situation is, we claimed these cities to be the victims of the terrorism financing issues in 2014, but now the cities, including Mariupol, Kramatorsk, Volnovakha, and Kharkiv, they are suffering the most from the Russian aggression. And if we could have the decision that could be enforceable on this terrorism financing convention before, maybe these cities would not suffer as they do suffer now. The other part of the case is racial discrimination in Crimea. The harassment of people in Crimea and the policy of Russian Federation on cultural erasure of Ukrainian community and Crimean Tatar community is extremely widespread in Crimea. People are disappearing. Russia doesn't closes Ukrainian and Crimean Tatar media. Russia does not allow people to study in Ukrainian and in Crimean Tatar. Majlis is banned. And again, as we see the parallel from the process on the terrorism financing convention with these times, now when Russia enters other cities, including Kherson, they try to use the same politics of cultural erasure of Ukrainians. Now, of course, the situation is worse because Russia in Kherson, they know people with pro-Ukrainian position, activists, the people who were participating in war, and they're attacking especially these people. But again, if the justice could be faster, maybe we could have prevented this the war that started again at 24th of February. Also, beside this, Russian Federation violated a number of provisions of the law of the Sea Convention. And we have 2 cases against Russian Federation on the coastal state right in the Black Sea, Sea of Azov, and the Kerch Strait, because we claim that Russia violates basic sovereign rights of Ukraine on the sea and usurped our rights there. This case is even more slow than the ICJ case, and we have filed our memorial also after negotiating with the Russian Federation only last year, and now we are waiting for the reply by the Russian Federation. We have also small cases, we call it, but it is also very important, on the detention of 3 Ukrainian naval vessels back in 2018 and 28 servicemen on board. This case was, the situation was very well known for the whole world when Russia captured Ukrainian Navy people. This case is also moving forward, and now we are expecting the decision on jurisdiction. Besides that, Ukrainian Ministry of Justice, the minister you have seen just recently, they have a number of cases in the European Court of Human Rights. These concern Crimea, Donbass, and a couple of different events, and one of these cases concerning Donbass is joined with the case of the Netherlands concerning the MH17, and now we are waiting for the decision on admissibility. And again, 8 years, still no decision, but a lot of numerous violations. And the case, the last case by Ukraine to ECHR was brought by the Ministry of Justice in March. And now they are finalizing their pleadings to be presented in summer to the ECHR. And finally, the Ukraine launched a new case against Russian Federation on 26th of February this year. We filed to the ICJ the claim. It is concerned in the alleged genocide. The case is about the fact that Russian Federation thought that there was some kind of genocide on Donbass made by Ukraine since 2014 and used this false allegation of Ukraine as a pretext for the special operation and full-scale invasion. And we think that this is the misuse by the Russian Federation of the Genocide Convention, and that's why we brought the claim on interpretation and application of the convention to the ICJ. And the ICJ ordered on 16th of March this year for Russia to stop its intervention and to bring their forces back to the position they had before the 23rd of February. This order is legally binding, and the court said it in its order a number of times that Russia must comply with it. Russia is not complying, and this breach creates another new breach of international law by the Russian Federation. This could be used also as a tool for compensation for Ukraine, besides what Minister Maluska was saying, the crime of aggression as well. So that's what we are trying to do, and of course we understand that we should bring not only to the accountability the people from the regime of Putin who made the aggression, but also those people who were raping Ukrainian women, who were shelling Ukrainian hospitals, who were killing people standing in the queues for humanitarian aid. And that's why we launch a huge criminal investigation. We have best prosecutors and investigators from Ukraine working in this case, but we are not alone, and we are joined with best prosecutors and investigators from Lithuania, Poland, and the ICC. And the investigation is still going, and we hope that, so the first indictment were already announced, and we hope to have more indictments as soon as possible on the war crimes committed on Ukraine. Thank you.
Thank you, Oksana. So Oksana already started talking about the importance that national criminal investigations have in the search for international justice. So I would like to present the other panelist that we have today, Mr. Alexander Gubrinovich, coming from the University of Warsaw. And we are pleased to listen to you while you elaborate more on the role that domestic judiciary have in the search for international justice.
Mm-hmm. Thanks a lot for your kind invitation. I congratulate this to undertake such a big effort to organize our conference. I try to switch on my presentation. Sorry. Oh yes, I have. The title of my presentation, as you can see here, is Domestic Judiciary as the Agent of the International Justice. Let me explain why this topic. Can you switch? Okay. I think that the reason is obvious. On the one hand, it is my deepest conviction that the main problem we are facing now is the one of the contingency. On the other hand, there is a robust evidence indicating that the crime of the aggression was really committed against Ukraine, and the expectations are increasing. There is increasing political pressure upon the decision makers all over the world to do something about it. On the other hand, we still cannot see clearly where finds the tribunal, international tribunal, which could prosecute and punish those who are responsible. When so, you must check the third best scenario. That is what is possible to achieve through the domestic avenue. Dear friends, the historical development in short. When you look at the history of the international law, it is quite easy to establish that as early as in 20s, Sir Lauterpacht openly stated that it is the role of the domestic judiciary to be an organ of the legal community. And of course, I'm not here to discuss all elements of the Lauterpachtian doctrine. We have no time for this. But I'm satisfied that he posited very clearly that domestic judiciary is not only to execute domestic law, the domestic judiciary is also to execute international law. And in this sense, it may be classified as an agent of the international justice as well. Interestingly enough, this Lauterpachtian doctrine found albeit limited practice after the Second World War. And here I can assure you that after the Second World War, in fact, we have in Poland some instances where persons were accused of having committed the crime of aggression, and they were prosecuted and punished in accordance with international law. So it's possible. By the way, when you look at the text of Sir Lauterpacht, he was not perhaps over-optimistic if it is about the setting up international tribunal. Even in 1944, he was a bit skeptical about the political feasibility. He was absolutely for, but the problem was not if, but how to get there, that such an international tribunal could emerge. When so, I think that his hesitation is similar to ours. We should do everything what is possible to establish the second best scenario, I think the tribunal ad hoc, but what if it is not a possibility? What is even more important, after the collapse of the Soviet Union, there is a current trend suggesting that, as a matter of fact, just because of the complexity of the crime of aggression, this specific crime should be reserved for the exclusive jurisdiction of the institutional tribunal. We have such a position clearly stated in the draft code of the Crimes Against Peace and the Security of Mankind, as adopted by the ILC in 1996. This idea was further widespread and supported by many eminent scholars, and now the question arises: why objections? Why there are people who suggest that it is not possible for the domestic judiciary to enter into this exclusive realm of the international justice? Now, the first argument is the possible conflict of position among states involved in an armed conflict. Usually it is indeed a problem. We have two states, they are go on war, and then they starts immediately quarrel who was the first to attack the other. But second argument is the necessity to secure impartial assessment by the international organ. So according to this logic, first we need to determine if the crime of aggression was committed, not the crime of aggression, if aggression as such, was committed as a serious breach of the international law in the sense of the Crawford Declaration as adopted in 2001, and only then it is possible to open criminal proceeding against those who presumably are responsible for these acts. And finally, there is a general belief, very often widespread, that domestic judiciary must not be impartial. That's impossible if it is a domestic judiciary. The intrinsic bias, they say, is a problem which may not be quite easily overcome. Let's hope and check how these arguments can be related to the case at the bar. Frankly speaking, I'm not satisfied with these arguments to block the Ukraine jurisdiction. So even if you will be lucky to apprehend Putin, I have no problem that if there is no such a possibility to send him back before the International Tribunal, to punish him in accordance with Ukrainian law. Why? Simply because when you look at the problem of presumed quarrel between sides, as a matter of fact, there is no quarrel. As a matter of fact, there is no quarrel. As Guterres very briefly stated, the problem is that the Russian troops are in Ukraine, but there is no Ukrainian troops in Russia. Interestingly enough, Lavrov said, "Это правда, подтверждаю." Good heavens. He almost admitted. If it is about the problem of control of determination, let me be very clear at the point. I concede that the Security Council was unable to adopt the decision based upon the Article 39 of the UN Charter. Correct. But nonetheless, when you see the line of decisions and resolutions adopted recently, starting with perhaps this resolution 2080, oh, sorry, I have no glasses, 23, if I remember. It is quite clear that the that the Security Council openly admitted that it may not fulfill the task assigned to it by the Charter because there is the unanimity between member states is lacking. And we have, as a follow-up, two extremely strong resolutions which leave no place for doubts who is the aggressor, where is the aggression state. And finally, if you look at the allegation that domestic judiciary must not be impartial, Sir Hirsch expressed doubts against these allegations. He even proposed some modification to strengthen this impartiality. I think we should take his text seriously if the second best scenario is not feasible for this reason or another. To sign up, Ukraine, absolutely different concern, has jurisdiction over these cases. Let me be very clear at the point. Most recently, it was reported by the press that Gerasimov was present over the Russian territory. Assume for a moment that Gerasimov is in hands of Ukrainians. Is anybody which is serious could protest against the investigation against him because of the crime of the aggression? I cannot see valid ground. Of course, there is political question. Perhaps it would be more opportune at this stage of the conflict to exchange him for, say, 2,000 or 3,000 of Ukrainian civilians who were deported. Okay, but this is the question, a political question, and we don't need to dwell now. My argument, however, is that as far as the matter is staying now, Ukraine is free to prosecute and punish for crimes of aggression. Although the question is how to get there, and what is the role of the third states? Here we entering the troubling water of the universal jurisdiction. I concede, but nonetheless, if we have if we admit openly, okay, that there is no international tribunal now, some organs must start the prosecutions. And I cannot see no other organs than domestic judiciary. Okay? So the sole issue which may constitute a procedural bar is immunity. And of course enforcement measures. But so long as the prosecutor offices in Ukraine, in other countries, collect the evidence, secure the evidence for the further proceedings. As an international lawyer, I'm satisfied. I'm satisfied it is okay with the existing rules of the international law, existing rules of the international customary law. So long, then the prosecutor office, domestic prosecutor office, does not issue arrest warrant against Putin, Shoigu, or something. I think that's absolutely not problematic. Okay, and finally. It is logical to expect that once international community decides to refer the cases of crimes of aggression committed by the Russian or Belarusian leadership before international tribunal, the national judiciary of a third country is effectively precluded from continuing the proceeding against the person, okay? Because in such a sort of situation, it is the role of the international judiciary, not domestic judiciary. But again, that's perhaps, and the last, and the last, perhaps these concluding remarks are a repetition, but we need to have a small time for our discussion. I would like to address the last remark to all those who are a bit afraid about the exclusive competences of the ICC. I think that just because of the arguments submitted by my learned colleague from Netherlands, just because of the singularity of the Ukrainian case, I don't see the future exclusivity geoparadise, even if we allowed domestic judiciary to prosecute and punish the criminals, okay? Because as you correctly observed, the singularity of the Ukrainian case is based upon the fact that we have very few clearly stated cases of aggression against of one state against another. That's all from my time. Thanks a lot for your patience and attention.
I think you are one of the few academics that are so enthusiastic about universal jurisdiction and prospect of success, but it's
careful. No, please don't. Well, I'm ready to accept the universal jurisdiction on limited basis. Okay, so.
Okay, so thank you. So now we turn to our online participants because we have two of them left in this panel, and I would like to give a sort of very fluent lead to the Dr. Sergei Sayapin, who is an associate professor and associate dean at KIMAP University School of Law. And he is ready to discuss about landmark criminal trials on charges of aggression, which took place in Ukraine. So, Mr. Sayapin, you can take the floor.
Thank you very much, dear colleagues. Can you hear me?
Yes, perfectly.
Thank you so much. Let me thank all the organizers for arranging this important conference and greet all participants from Central Asia. As we are discussing the prospects of criminal responsibility of the authors of Russia's aggression against Ukraine, I think it will be useful to recall Ukraine's recent experience of prosecuting individuals for aggression and to discuss some lessons from those criminal trials. As a matter of fact, Ukraine may be the only state in the world which has prosecuted anyone for aggression in the past 70 years, and learning from those trials may be useful. First of all, the Alexandrov and Yerofeev trial, which took place in 2015 and 2016, was the first criminal trial on charges of aggression since the conclusion of the Nuremberg follow-up trials in the second half of the 1940s. While the interpretation of the crime of aggression handed down by the judgment was somewhat debatable, it still was the first judgment resulting from charges of aggression in a criminal trial in decades, and as such, it certainly merits attention. Let me briefly recall some facts of the case. On the 18th of April 2016, the Golosievsky District Court in Kyiv pronounced a verdict in a criminal case against Alexander Alexandrov and Yevgeny Yerofeev, both ex-military servicemen of the armed forces of the Russian Federation. Alexandrov and Yerofeev were found guilty of a number of crimes under the Criminal Code of Ukraine, including Article 437, paragraph 2, and sentenced to 14 years imprisonment. The judgment, after it was handed down, was not appealed. On the 24th of May 2016, President of Ukraine, Petro Poroshenko, pardoned Alexandrov and Yerofeev, and the next day they were exchanged for Nadia Savchenko, a Ukrainian national and former military pilot who had been sentenced to 25 years imprisonment in Russia, pardoned by the President of Russia, and both of them departed Ukraine on the same day. Article 437, paragraph 2 of Ukraine's Criminal Code criminalizes waging a war of aggression or the conduct of aggressive hostilities. Please note that the disposition of this provision is in the alternative. In other words, it is sufficient for the purpose of criminal responsibility that an individual commits either of the two acts referred to in Article 437, paragraph 2. Alexandrov and Yerofeev were convicted for waging a war of aggression by a group of persons with prior arrangement under the first alternative. I submit that this choice was somewhat confusing. The first alternative of Article 437, paragraph 2, in accordance with customary international law, requires that an alleged crime be committed by a state's highest-ranking political or military official who is capable of triggering the use of force by that state in violation of international law, whereas the second alternative does not necessarily contain such a requirement. Hence, to avoid any confusion, the court could have made an explicit reference to the second alternative presented by Article 437, paragraph 2. Unlike the planning of, preparation for, launching or waging a war of aggression, which can only be committed by political or military leaders of a state, the conduct of aggressive hostilities could also be imputed to individuals at lower levels who actually take part in aggressive hostilities. In turn, the Yanukovych trial was the second criminal trial on charges of aggression since the beginning of Russia's aggression against Ukraine in 2014. Notably, Viktor Fyodorovich Yanukovych was the second former head of state, after Karl Dönitz, to have ever been convicted for a crime against peace. On the 24th of January 2019, the Obolonsky District Court in Kiev pronounced a verdict in a criminal case against Viktor Yanukovych, former president of Ukraine, on charges of high treason and complicity in waging a war of aggression. Notably, he was acquitted of charges under Article 110, paragraph 3 of the Criminal Code of Ukraine, that is, infringement of territorial integrity and inviolability of Ukraine, because the court was not satisfied that Yanukovych had possessed a mens rea required by that crime. In accordance with Article 297/1 of the Criminal Procedure Code of Ukraine, Yanukovych was tried in absentia and was sentenced to 13 years imprisonment. In assigning the punishment, the court did not identify any aggravating circumstances and noted that Yanukovych, when committing his crimes, was under the influence of agents of the Russian Federation. Interestingly, Yanukovych's predecessor, if you want, in committing crimes against peace, that is the only other former head of state to have been convicted of the said crimes, Karl Dönitz, was convicted of waging a war of aggression, but not of conspiracy, because Dönitz had not been involved in the planning, preparation, or initiation of Germany's aggressions. The Obolonsky District Court probably decided to follow that precedent, but was somewhat inaccurate in factual and legal terms. In fact, Yanukovych's conduct was almost exactly opposite to the conduct of Dönitz. That is, Yanukovych was instrumental at the preliminary stages of aggression against his country, but he was not in any way in control of its waging. And the court even agreed that Yanukovych could not foresee and probably did not desire some specific consequences of Russia's aggression against Ukraine, such as the Russian occupation of Crimea. Another important difference was that Dönitz was convicted of his role in Germany's waging wars of aggression against other countries, whereas Yanukovych, by issuing an invitation addressed to Putin to use force against Ukraine, assisted another country in committing an act of aggression against his own country. The qualification rules require that among competing definitions of crimes, a more specific corpus delicti should be imputed. Therefore, Yanukovych's conduct could have been probably more accurately qualified as a conspiracy under Article 437, paragraph 1 of Ukraine's criminal code, instead of complicity in the waging of a war of aggression under Article 437, paragraph 2. And now, dear colleagues, let me suggest a few lessons which may be learned from these previous trials for the purpose of the future aggression trial, and make a few practical suggestions. And here I will try to make my suggestions not repetitive of Professor Blocker's excellent ideas, which he explained earlier in his presentation, but rather complementary to them. First, Ukraine does have a sufficient legal basis for the criminal prosecutions, but judges dealing with such cases should receive further training on international criminal law and specifically on the crime of aggression. This will help avoid inaccuracies in the qualification of the imputed crimes and ensure an impeccable quality of justice. No doubt, Ukrainian judges in the cases I've just discussed should be credited for their contribution to the rule of law and to the rule by law, given their pioneering role in administering justice with respect to the crime of aggression in contemporary legal history. However, the quality of justice in the future aggression trial should be beyond any criticism. Second, depending on the chosen format of the future tribunal, in addition to Ukrainian judges, the participation of foreign judges, as well as prosecutors and defense lawyers specializing in international criminal law, could be foreseen. Such a mixed setup would make the trial truly international, ensure the representation of different legal traditions and schools of legal thought, and elevate the quality of the trial both in symbolic and practical terms. Third, the substantive legal basis of the future trial will be key. As we heard a few minutes ago, the definition of the crime of aggression in the sense of Article 8 bis of the Rome Statute of the International Criminal Court will not be applicable on formal grounds. Therefore, the proposed tribunal should be enabled to apply Ukraine's and probably Russia's domestic criminal law. The relevant provision of Russia's criminal code is fairly, although not entirely, equivalent to Article 437 of the Criminal Code of Ukraine, with due regard to customary international law. And it will be very important to show that Russian political and military leaders have committed crimes not only under Ukraine's domestic criminal law and international criminal law, but also under the law of their own country. Fourth, it will be crucial to ensure a workable procedural legal basis. Depending on the factual circumstances at the time of the future trial, Russia will be more or less reluctant to cooperate with the proposed tribunal. This is clear. It will therefore be important to ensure procedural cooperation on the part of a maximum of other states. This will show the acceptance of the tribunal's legitimacy by the international community and contribute to the successful achievement of its objectives. And last but not least, full transparency of the trial and compliance with the fair trial guarantees will be important. Given the gravity of the crime of aggression, the high-ranking status of prospective defendants, and controversies which inevitably will surround the trial, it will be critically important to ensure its objective coverage, both offline and online. The presumption of innocence must be included in the statute of the tribunal, and all fair trial guarantees must be in place for the defendants, in accordance with customary international law. I believe that compliance with the superior standards of justice will make the trial not only truly historical, but also will show the triumph of law and justice over barbarity and cruelty. Thank you very much for your kind attention.
Thank you. And the last panelist to make introductory remarks that has joined us is Olga Butkevich, President of the Ukrainian Association of International Law. And the way that I see it, if you, Olga, would be possible to make sort of a wrap up, on the things that we have been talking in this panel, because I know that you also have the idea to talk about institutional and normative perspectives of different legal formats that we have of responsibility to be ensured. So it would be great, if you could sort of finalize and give your overview and your own outlook, how you see this situation of different legal solutions that could be there.
Thank you very much. I suppose that everything is okay with the sound. First of all, I would like to thank the Ministry of Justice of the Republic of Lithuania, also Law and Democracy Center, Justice Hub, and especially Professor Dainius Žalimas for the organization of this event and also for the constant and reliable support of Ukraine. Each time when a serious crisis in international relations occurs, doubts in international law and its efficiency grows. And we also have seen that during the whole discussions. As well as it is true that from each crisis, international law came out strengthened and more humanistic. Thus, one of the most crushing European conflicts, I would just turn somehow to the history of international law and to remind that one of the most crushing European conflicts, the 30 Years' War, was ended by creation of a lasting era of Westphalian international law. The World War of the 20th century, I'm calling it in singular, ended first with the formation of a universal organization and the first universal court, the Permanent Chamber of International Justice, and then in 1945 with the creation of the United Nations law and incredible breakthrough in human rights, international criminal law, and the prohibition of the use of force in international relations. Today, the world order once again faces its crisis, but it is during this crisis that the features of the future international legal order are being formed. And it is very important not to waste time and to outline these features just now. To make some decisions and to make some conclusions, it is important to outline the causes of the crisis. After all, today it is already clear that we are not talking about the local Russian-Ukrainian conflict. That is the world war of totalitarianism with democratic values and decivilization with civilization. Russia's armed aggression against Ukraine began on February, but it was not on 24th of February, it was earlier on 20th February, and not in 2022, but in 2014. Also, I would like to remind that hybrid war against Ukraine has lasted since 1990s. Also, this aggression of this year, the aggression of 14th year was accompanied by an attempt to annex Crimea and to occupy some parts of the east of Ukraine. The reaction of the international community to Russia's aggression in 2014 was completely insufficient. All 8 years, it was characterized by a policy of appeasement of the aggressor. And that policy eventually led in 2022 to the unprecedented large-scale war in Europe with international crimes such as war crimes, crimes against humanity that acquired in Ukraine mass character and even a crime of genocide. The Russian-Ukraine war has demonstrated the weakness and, in fact, the inaction of the European and even universal system of collective security. All that infringes faith in international law. But is it international law that is a problem? In recent decades, excellent fundamental rules have been established in international law. These are prohibition of aggression and ban on the use of force in international relations, unconditional respect for sovereignty and territorial integrity of states. International humanitarian and criminal law have developed seemingly perfect sets of rules, safeguards against armed conflicts. If there is a need to change anything in international law and set of these rules? Of course not. Does the mechanism of application of these norms work? Also not. In the same last decades, we have witnessed the transfer of the center of influence in international relations and also in most countries from the supremacy of law to political expediency, economic interest, and even populism, including electoral populism. It is these factors that are decisive, and they are what prevented the world community in 2014 to fight out gross violations of international law. Therefore, there is a need to revise current system of collective security, both institutionally and in a normative way. From this point of view, let me really conclude our discussion and sketch some outlines of the future decisions or the future possible decisions in the way to establishment of future architecture of the world order. The first steps here could be the following. First, the establishment of the Special Tribunal on Russian aggression, and since 2022, also the Republic of Belarus, which takes part in committing this crime. So that what is under our today's discussion. Second, initiating the adoption of the strict and stable multilateral European, or even better, the UN document on the prohibition of the crime of aggression against a sovereign state and the punishment for this crime. Such a document could be based on the UN resolution definition of aggression, and also it could be guaranteed by the proper monitoring and or judiciary mechanism or the link to the ICC. Third, our panel is called Crime of Aggression, International Criminal Court and Other Possibilities. So among other possibilities, there is reforming of the security component of the UN system, including regulatory and legal mechanism for unlocking the work of the UN Security Council, amending the statute of the International Court of Justice regarding its mandatory jurisdiction over issues of international peace and security, and strengthening guarantees for the implementation and realization of its judgments, of its decisions, and creation of a permanent UN peacekeeping contingent for operative within 24 hours, counteracting to the threats or to civilians and civilian infrastructure. Fourth, when we are talking about Russian-Ukrainian conflict, we usually use such a wording as hybrid war. One of the manifestations of the hybrid war is economic aggression. And here, when we speak about aggression and counteracting to it, I would like to stress this one. Economic aggression was committed by Russia against Ukraine, and Russia waged economic wars against Ukraine since the very first years of 21st century. Especially, these were the economic pressure, it was the economic pressure to compel Ukraine to refuse from the ratification of the association of agreement with the EU in 2013, which led to the revolution of dignity. The adoption of an international legal instrument that would prohibit economic aggression and explicitly invalidate any action taken under the threat of economic pressure, economic threat, is needed. That was not done during the Vienna Conference on the Law of Treaties, but it can be done now. The clear principle is needed that a treaty would be regarded void if its conclusion has been procured by the threat or use of economic force. And maybe the last one, criminal prosecution. In order to properly implement criminal justice here in this conflict, all existing institutions should be involved and new ones created. The Special International Tribunal for Russian aggression, the ICJ, the ICC, the European Court of Human Rights, and also national courts with hybrid character, both municipal and international character. It is worth also, in this context, it is worth to support the idea of the so-called Kharkiv Tribunal over Russian militaries and Ukrainian collaborates. The response to hybrid aggression, like the hybrid war itself, must be multi-vector. And in this process, no aspect of this war can be overlooked. Propaganda, trade and economic pressure, terror and intimidation, cyber attacks, the use of satellite states and international terrorist groups, etc. All that should be regarded as an integral part of an aggression, and all that should be punished. All institutional and normative efforts should be directed against tactics of appeasement of the aggressor and any violator of international law. And such tactics must forever go away from international relations. Half a century ago, in 1970, a prominent world lawyer who was also mentioned here, for sure, he was mentioned, prominent lawyer of Lviv origin and one of the ideologists of the Nuremberg trial, Herr Lauterbach, has defined international law as the law of international community. Today, it is clearly paved the way from interstate law to the law of international civil society. The crime of aggression today is twofold. It is the crime against the interstate system, and it is the crime against the international community. So the establishment of a special tribunal on Russia's aggression was an initiative and manifestation of the action of the international community. As from other crises caused by the tyranny of states and arbitrariness of states, from current war, international law and the world community will get out stronger. Effective work on the establishment of the special tribunal over the Russian aggression is a testament to this process. Thank you for your attention.
Thank you. As we are almost on time, I would like to thank all of you, and I think we had a good food for thought for the last panel that we have on the Special Tribunal, because I think it was very clear from the message that Professor made that ICC decision is not for the Russia of today. And we have to look for legal solutions for the Russia that is today. Because maybe, you know, we have regime change and maybe happens something in the future, but the problem we have to solve is the problem we have today. And I wish that constructive discussion happened in the last panel. And for now, I would like to invite all of you to have a lunch for 1 hour and a half, and then to have a coffee, and please be back on time so that we can start on time and finish on time. Thank you very much. And the restaurant is downstairs, so you just follow the signs and you will find.
It's time to start our panel. I'm happy to be a moderator in such large panel consisting of really well-known authorities in public international law and international criminal law, and it is like logical continuation and at the same time finalization of our conference. Its main topic is namely the idea that gathered us here. It is the Special Tribunal for the aggression against Ukraine, including all the particularities on jurisdiction, modes of establishment, composition, immunities, and many other issues. And I am pleased, first of all, to introduce to you the first panelist, who is Professor Philip Sands, Professor of Law at University College London, also visiting Professor of Law at Harvard, practicing barrister at Matrix Chambers, who also appears frequently as a counsel before the International Court of Justice and other international tribunals, sits as international arbitrator. He is also an author of a number of books and articles, including articles in public press. And would you excuse me? I will not mention all of your books. We are really pleased to see you here today, and I would like to ask you to make a sort of introduction about the very idea which appeared in the combined statement and declaration, and the significance of tribunal to the whole system of international peace and security, maybe also the campaign for promoting this idea and preparation of its statute. Please.
Oh, well, thank you very much for the generous introduction, and my thanks to the government of Lithuania for hosting this meeting and for inviting us. It's an incredible pleasure to be here. Some of us have been in touch, but only by Zoom, and to actually be physically together, it really is a wonderful thing. So we all know the day the war began, and about 36 hours after the invasion occurred, I received an email from the editor of the opinion pages of the Financial Times in London, for whom I occasionally write. She said, given your connection with Ukraine, given your book East-West Street and the origins of the concepts of genocide and crimes against humanity and the city of Lviv in western Ukraine, could you write 700 words for us on anything you want on Ukraine and international law? I spent about 24 hours thinking about it, and then literally 2 hours actually writing. And the subject that I focused on was what for me was a major gap in the delivery mechanism for the rules of international law that exist, and that concerned the crime of aggression. I did a little research on how I wanted to write the piece, and I focused, for those of you who've read the piece, by way of introduction, on a meeting that was held, probably quite similar to this meeting, in London on January the 13th, 1942, when a number of governments in exile from various European countries gathered and adopted a text that is known as the Declaration of St. James. The Declaration of St. James put forward the idea that perpetrators of crimes in Nazi-occupied Europe should be subject to punishment. And that idea, of course, then morphed into the United Nations Commission on War Crimes, Yalta, and in the summer of 1945, the London Agreement that created the International Military Tribunal. When those individuals met in London on January the 13th, 1942, it seemed completely improbable that anyone would ever be in the dock. But just 3 years later, as we know, everything had changed. And that inspired me to propose in my opinion piece that there be created a special criminal tribunal to deal with the crime of aggression in relation to Ukraine. I must confess, if you had asked me at the time, would I expect to find myself just a few weeks later sitting at a meeting with such participants discussing the modalities, I would have said no chance. But once ideas get out there, we know they can run. Very shortly after the article appeared, 2 different sets of communities got in touch. The community around now my very dear friend Mykola, Professor Niatovsky, with whom I've been in very close contact, but I've known for many years, who was the advisor to the Minister of Foreign Affairs of Ukraine, who shared with me that actually the minister, Mr. Kuleba, had actually written an article on the Declaration of St. James. There is an absolute synergy here in relation to the subject that we're talking about. And we talked, and around the time that we talked, I received another communication from a gentleman you heard from this morning, the former Prime Minister of the United Kingdom, Gordon Brown, who simply said, I read the piece, I'd like to help. I think this is an idea that should be promoted. I'll open my address book and get in touch, and some of the people are here as a consequence of that. It's one of the things that you don't know when you're not working in those echelons of government, that they all know each other. There's a sort of club of former presidents and prime ministers and senior characters, and they all arranged Zoom meetings with each other, and very soon things began to happen. The simple point is that one thing led to another, and did so very quickly. And it did so, I think, because people have understood a number of points, and I'll be very brief before we then open up. The first is, such a special tribunal has precedent. It has precedent in relation to a multilateral agreement between states, Nuremberg, Tokyo. It has precedent in relation to an agreement between Ukraine and an international organization, Kosovo, Sierra Leone. There are numerous other examples. Secondly, and most significantly, this is not like Nuremberg in 1945. There is substantive law. There is a crime of aggression, not only in international law, but in the law of Ukraine. In spending those few hours researching the article that I wrote, I came across, or I revisited the work of a very fine American scholar, Francine Hirsch, who'd written a wonderful book, which I think is worth getting and looking at, called The Soviet Union and Nuremberg. And from this, and then in conversation with her, I learned the idea of crimes against peace, as it was then called, but today crime of aggression, actually originated with a Soviet jurist, Aaron Trenin, who had to persuade the British, Americans, and French to insert it into what became Article 6 of the Nuremberg Statute. So there is a very direct connection, an attractive connection. And then after the Nuremberg Tribunal gave its judgment, the crime of aggression was integrated into the penal codes of the Soviet Union, Belarus, and Ukraine. In other words, that left the situation that essentially what we are talking about is an international delivery mechanism to assist Ukraine in prosecuting, investigating and prosecuting what is manifestly a serious violation of international law. It is not something that the ICC can do. It is something that Ukraine can do in its domestic law, but for very good reason, I think. This is the one thing that ought to be internationalized. Many of you will recall that the Nuremberg judgment described the crimes against peace, the crime of aggression, as the supreme crime. All the other crimes that were adjudged at Nuremberg flowed from the crime of aggression. And that is, in fact, exactly the same thing in this situation. If we did not have an invasion that was manifestly illegal, we would not be talking about war crimes or crimes against humanity, or even, as some are, talking about genocide. And so that meant for me it was the ultimate crime in this dreadful situation that we now face, and that gap must be filled. 2 final points. The scenario that worries me greatly is that in 3 or 4 years' time we will find ourselves in a situation in which there are proceedings in national courts, Ukraine, Germany, Poland, other places, the International Criminal Court, certainly for war crimes, maybe also for crimes against humanity, but there's only a focus on mid-level or low-ranking people who may have committed crimes but are not the principal individuals responsible for what has happened. Those who took the decision, participated in the decision, supported the decision, financed the implementation of the decision, and so on and so forth. You're probably talking about 20 people. And the second point in relation to that is this crime of aggression is the only one, it is the only one with absolute certitude that you get straight to the top table. The other crimes may lead to the top table, but proving the involvement of Mr. Putin, Mr. Lavrov, the defense minister, and others in connection with some of the terrible things that we are seeing on our screens and that some of you have witnessed much more directly is possible, but it's going to be requiring a lot of energy. And my fundamental concern on justice and accountability is that it must reach the top table. If it does not reach the top table, it will be a failure. It is not sufficient to look at the lesser individuals who are behind this. And that was what I evoked in the piece, and it's a very great privilege to be on this panel with everyone this afternoon and with this distinguished audience to talk through the modalities of how we do that. Thank you very much.
Thank you very much, Professor, for an excellent overview. Indeed, we're going to explore many issues touched in your presentation. And now I am pleased to introduce to you next speaker, who is Mykola Gnatovsky. As it was told, he is professor of Taras Shevchenko National University of Kiev and advisor to the Minister of Foreign Affairs, but we can also congratulate him with new appointment, as far as I know, from July. Yes, professor is elected to the European Court of Human Rights from Ukraine. So our joint congratulations, and as it was indicated, your topic would be, for introductory remarks, of course, the issue of aggression from Ukrainian legal and political perspective, the call that emanated from Ukraine for the establishment of a tribunal, and the impact on the ongoing armed conflict. So please, the floor is yours.
Thank you very much, Professor Žalimas, and I'd like to start with thanking wholeheartedly the government of Lithuania and the Ministry of Justice in particular, the minister, the deputy minister, and to you, of course, Professor Žalimas, dear Dainius, for setting up this, for organizing this conference so brilliantly. And that is hugely helpful, not just for us to finally meet in person after many years and after so many conversations in video conferences, but just because this is the right moment, I think, to enhance the momentum that already exists for the creation of the tribunal, and these discussions should be hugely helpful. So thank you very much for this. I was very happy to listen to all the presentations and discussions this morning, because so many important points were made that completely laid out the scene so clearly that now I think we can speak specifically about the proposal to create the special tribunal. And let me continue a little bit at the point where Philippe has left it. Because, again, looking back several weeks ago, when the Russian aggression against Ukraine has turned into a fully fledged war, fully fledged invasion, I as somebody who has never worked for the state as such, and who stayed away from public service, I had to contact the foreign minister and basically to tell him, well, benefiting from our old friendship, that if there's anything, is anything that I can do to be helpful to Ukraine, I would be doing just that and nothing else. And he said one word: aggression. So what you need to do is to concentrate on the act of aggression and the crime of aggression. It should be recognized universally, and ways should be found to hold the Russian leadership and Russia as a state responsible for what it is doing. I started by contacting various associations of international law and various national societies and so on. And I saw that actually they didn't need to be prompted to very quickly issue powerful statements qualifying the things as they should, including not only the national societies or the ILA, but for example, l'Institut du Droit International also published a very, very helpful resolution in this respect, and others. So it was obvious for the College of International Lawyers what was happening, and that the qualification is crystal clear. And indeed, as already mentioned during the morning session, there hasn't been a war of this scope in Europe since the Second World War, perhaps with the exception of the war surrounding the breakup of Yugoslavia. But again, this is a war of aggression, basically a war against territorial integrity and political independence, and in fact the very existence of a major European state by another major state. And this is something that was obvious that in legal terms. But now the question is, as the substantive law was there, as Philippe has just said, that there should be mechanisms around this. And that's why when Philippe published his piece in Financial Times, and also we got in touch, and he was also in touch with Minister Kuleba, who immediately understood the proposal, as he has international criminal law background himself, luckily. We started working on this, and I was so impressed by Philippe and those colleagues who have joined this enterprise, and I'm delighted to see here Dapo Akande and Alex Whiting and Arif Abraham, and those who have worked with us, also Gordon Brown, who spoke earlier today. This has been a fantastic experience, and it was obvious that we are there to find ways to make sure that the accountability becomes real, that the accountability is there. So it is not a question what needs to be done, it's a question of how it needs to be done. Turning it slightly from a different angle, looking at it on a different angle, I would say that it's no longer viable to try and discuss why a mechanism cannot be created to hold those responsible for this war of aggression accountable for it. But it's a question of what do we do and how we ensure that this actually happens. And in fact, whilst the war is ongoing and the hostilities are progressing, we are seeing evidence of shocking war crimes, crimes against humanity. And there's unfortunately a very serious discussion now, even invoking the notion of genocide, which is unfortunately on the table somehow. And it is very present in the political statements made by world leaders. And this should by no means distract the attention from the original crime, for the crime from which it all flowed, as Philippe has mentioned, the crime of aggression. Also because there is institutional architecture for to prosecute atrocities. It is a very difficult task for sure, but the ICC has jurisdiction, and there's efforts at the national level by Ukraine, by a few other states, including Lithuania and Poland and a few other countries. So there would be also, use will be made of universal jurisdiction perhaps, and certainly it will be possible to find, hopefully, to find a way to ensure that the ICC and the national jurisdictions interact in a way that would be appropriate for the crimes of this level. But the crime of aggression, nevertheless, has to be addressed in the first place. Also because sometimes one is astonished about the discussions on the war crimes. It's very difficult to prove war crimes, in fact. The discussion whether the initial target was a lawful one or not can last forever. The discussions about whether the principle of proportionality was actually adhered to or not, whether precautionary measures were taken or not, and things like this, they can really drag for many years. And these are not things which are so clear, unlike the crime of aggression. In the paradigm of the crime of aggression, there isn't a single lawful act which is being committed, which is being carried out by the aggressor state, because the crime of aggression is a continuing crime. It's not just the decision to invade another country. It's also everything else that is being done in the implementation of this decision, in waging of this war. And that's why when now there's discourse that in fact these things are not so straightforward, and perhaps in many cases it's just the military objectives that are being targeted and so on, they become much less relevant for this particular topic, because the distinction between jus in bello and jus ad bellum issues should not be used here by those who have attacked the very basic foundations of international legal order to evade responsibility. So that's the gist of it. And then, of course, the proposal to set up a special tribunal, which is, I think, meeting with a lot of understanding everywhere, is just now about the ways how to implement it, whether it is done through a multilateral treaty, whether it is done through a treaty between Ukraine and an international organization, whether there's a collective effort by states who are ready to be more active at this stage, which can be endorsed and supported in various ways by other states and international organizations. There's plenty of things to do, plenty of ways to achieve the goal. But this discussion should not distract us from the need to address the issue as a matter of urgency. Luckily, if one can use this word in such a grave, in fact terrible context, it is not particularly complicated to investigate the crime of aggression. There are things there which need to be approached very carefully, but the very fact that already in the public domain we have at least 2 draft indictments for the crime of aggression against the top Russian leadership is very telling, because these are done by academics, by lawyers who never left their office to write them. But so it is something that is perfectly achievable. In the political context, and I will be wrapping up here, Danius, in the political context, this is a highly important decision. And of course, one has to completely realize that even indicting a sitting head of state and other top officials of the state is not simply about the way of delivering justice. It is also a very important political decision. The political decision that shows that this kind of wars of aggression of this scope and with such goals as almost openly declared by the Russian leadership, again as discussed very profoundly this morning, they will not be tolerated, no matter what. In a way, this might be seen as somehow, by some, and I would understand that completely, as a point of no return. But do these circumstances not warrant such an approach? That's my question, and I think it's a rhetorical one. Thank you very much for your attention.
Thank you. Thank you very much, Mykola. And now we can continue on the law relating to aggression, namely also jurisdictional, to start with jurisdictional issues of a possible tribunal and how it can be derived for the tribunal, from which sources. And I am pleased to introduce to you Dapo Akande, who is representing Faculty of Public International Law of University of Oxford, and who is also a member of the UN International Law Commission from 2023. So please, the floor is yours.
Thank you very much. Thank you for the kind introduction. And like all the others, I also want to join in thanking the government of Lithuania, and in particular the Ministry of Justice and the Vice Minister for organizing this. I would like to spend the time that I have talking about the how. You know, we've talked about how might this tribunal be created, and we've mentioned various possibilities. And really what I'd like to do is to set out what the options are, and then to talk a little bit about why, or how rather, the choice of option might matter. So the first thing and the starting point is that we're talking about what we've all been describing as a special tribunal, a tribunal that has an international element. And so there you have, essentially, we're talking about a tribunal that finds, in some sense, a legal basis in international law. And by that I mean that it is created by agreement between Ukraine and either an international organization or between Ukraine and a number of states. Now I say a tribunal that finds its legal basis in international law in that sense, but it's also important to note that we're also talking about a crime which occurred on the territory of Ukraine, and with respect to which Ukraine has jurisdiction both under its own national law, but which international law confers jurisdiction on Ukraine. There's a territorial jurisdiction that is conferred on Ukraine by international law. So even though we're talking about a tribunal that will have an international basis in the sense that it is created by way of an agreement between Ukraine, a treaty basis between Ukraine and some other entity, be it state or an international organization, as with all other international criminal tribunals, really the legal basis for the exercise of jurisdiction by these tribunals is one which operates by delegation from national jurisdiction that these entities have to the international body. And that's true even of the International Criminal Court, that essentially what you have is states coming together to delegate a jurisdiction that they have to the International Criminal Court. So what are our options? So option one is to have a tribunal that's created by agreement between Ukraine and the United Nations. And there, of course, we have existing models. We have the model of the Special Court for Sierra Leone, where you had an agreement between Sierra Leone and the UN. In fact, the UN Secretary General entered into that agreement, but on a mandate from the General Assembly. And so in that sense, you don't need the Security Council. It could be the General Assembly mandating the Secretary General to enter into an agreement with the UN. So that's option one. Just to list the options and then to come back to them. Option two would be an agreement between Ukraine and a regional body. Could be the Council of Europe, could be the European Union. And there also we have precedents. So for example, the tribunal that Alex is a part of, the Kosovo Specialist Chambers, you have an agreement there between Kosovo and the EU. We've also had precedents in that regard, and I will return to this later on actually, outside of Europe. So we had the tribunal that prosecuted the former Chadian head of state, Hissène Habré, which was a tribunal with the support of the African Union. And so that was a tribunal that was established by agreement between Senegal and the African Union. And then the third option would be an option which is a tribunal that's created by agreement between states. And there, of course, you can imagine that it could be a large number of states, a small number of states, whatever it could be. And in one sense, that is, at least as far as legal basis is concerned, not dissimilar to the International Criminal Court. Of course, the International Criminal Court has 123 states parties, but they're all states. They're all states that have created it. And there are also other precedents. Again, on the African continent, African states recently agreed a few years ago, the Malabo Protocol, an agreement between the members of the African Union to confer criminal jurisdiction on the African Court of Justice and Human Rights. Again, it's just an agreement between states. So you could have the question is how many states, but as far as legal basis is concerned, it's between states. So those are the options, and the question really is which option is best and does it matter which way you go? And there, essentially, there are political issues that one might consider and there are legal issues that one might consider. So in terms of the political issues, I think the thing that tends to be at the top of people's minds are questions of legitimacy. You want a tribunal that has the greatest degree of political support. That's one consideration. But of course, to the extent that you support the idea of having a tribunal, the first thing, I guess, is you want a tribunal. And what I mean by that is there might be some possibility, there might be some of these options that are possible, and there might be others that are just not possible. So in terms of wanting an option that has the greatest degree of political support, one might say you look naturally at the UN General Assembly, because if you can get a wide degree of support, that confers legitimacy. But the question is, can you get it? The other question that arises in relation to these political issues, the issue of legitimacy, and there's been a lot of discussion about considerations of selectivity and considerations of, well, if you can't do it through the UN, is it worth doing at all? Because does this send the wrong message as to the delivery of international criminal justice? And there, I'd just come back to the points that I've been making about the precedents. This will not be the first tribunal that would be created on a regional basis. So I've already given examples of tribunals where you have a regional organization that enters into an agreement with states. And also, and I think this is important, some of the questions that are being raised around selectivity, particularly in relation to Europe. So the argument is sometimes made, well, would this just be another example of attention being given to something that is happening in Europe? And is that the reason? And it's exactly for that reason that I mentioned the two African precedents earlier on. So the Habre tribe, the African Union has actually been very keen on regional international criminal justice. And that has been supported, not just in Africa, but elsewhere. And that was the reason for having the tribunal that prosecuted former President Habre. And that's the basis of the Malabo Protocol, not yet in force, but it's the basis for saying that there should be the possibility of exercising jurisdiction on an African basis. So I think the argument that this would just be something being done in Europe actually wouldn't be the first in doing this. There would actually be others. And the interesting thing is, the Malabo Protocol, established by the African Union for the African Court of Human Rights and Justice, it includes jurisdiction over the crime of aggression. It would actually be the first, not in force, but there is already jurisdiction on a regional, I mean, when I say already, there's a treaty that is adopted on a regional basis that provides for the crime of aggression in Africa. So I would reject the idea that this would be something that's just special for Europe because we already have other precedents. So those are political questions relating to the basis. The last thing that I will mention, and this is the issue of, does it matter as a matter of law which of these options you go down? Now, all these options I think are legally available. One issue that is often raised is, to what extent does it affect the question of immunities? So because aggression is a leadership crime, we are talking about the potential of prosecuting people who have immunities under international law. And here I focus just on immunity ratione personae. So the first thing to note in relation to immunities is that we're only talking about 3 positions that attract this immunity under international law. And this is not coextensive with those who are subject to the crime of aggression. So it's the head of state, head of government, and foreign minister, to the extent that they are in office. However, the question is, does it matter which of these options if, to be able to deprive these individuals of immunity? That depends on the position that one takes on this question of immunity. So one view is to say that if it is an international tribunal, any international tribunal at all, then there will be no immunity ratione personae. And that's the position that was taken by the appeals chamber of the International Criminal Court in the Bashir case, the case against the then Sudanese president. Now, I hasten to say that not everybody shares that view. But if you take that view that the ICC appeals chamber took, then on any of these models, because it's an international tribunal, there would not be immunity. The second option with regard to immunity, a position that has been taken by some, is to say that in circumstances where you have a tribunal, and this Latin expression is often used, which represents the jus puniendi of the international community. In other words, it's sort of representing the ability of the international community to repress these crimes, then immunity would not exist. And there it might matter. It might matter whether or not you say the tribunal is one which is representing the international community. Again, that's not a view that is necessarily shared by all. And then the third thing that I would say on immunity, and this would be the last thing that I say, is that there's another view in relation to immunity, which would be to say that in circumstances where you have a state that is exercising, in effect, a right of self-help, something that is akin to countermeasures or something that you might derive from the right of self-defense in responding to an act of aggression, that in those circumstances there would not be immunity. And that would be the case whichever of these options you go for. So let me stop there.
Thank you very much. And now I think the most logical would be, because you mentioned a few times about the existing precedents for the creation of various international tribunals. So I'm pleased now then to give the floor namely on this topic to the next speaker, Arif Abraham, who is a barrister specializing in public international law, international criminal law, and human rights. He advises to parliamentarians, NGOs, and international organizations, drafted a number of various legal instruments, and he is also founder of Accountability Unit, that is an NGO specializing in conflict resolution and justice issues. So please, the floor is yours.
Thank you very much. I'd like to begin by thanking the Ministry of Justice of Lithuania, the Vice Minister, and also Professor Zalimas for the invitation to speak today. I'm really grateful to be here with this distinguished panel. I'd like to make really three short points. First is to really build on what Dapo was saying in relation to the precedents and outlining the extent of the precedents for setting up a special tribunal. Second, exploring some of the best practices in relation to any agreement or statute that might be the basis for a special tribunal, particularly in light of some of the objections that have been raised by some commentators. And then third, consider the issue of practicality of getting an agreement signed between willing states. In relation to precedents, I have identified approximately 25 relevant agreements since the 1929 Kellogg-Briand Pact, which is often cited as the precedent for the prosecution of German and Japanese leaders for waging wars of aggression post-Second World War. 10 of those are particularly relevant. Some of them have been mentioned by my colleague Dapo. The first, of course, is the 1945 Charter, an agreement on the international military tribunals. There's the 1903 and 94 statutes on Rwanda and Yugoslavia. There's, of course, the 1998 Rome Statute, which was obviously amended in Kampala in 2010. In 2002, there was the agreement between the UN and Sierra Leone for the Special Court. 2003, agreement between UN and Cambodia on the extraordinary chambers. 2007 was the agreement between the UN and Lebanon on the Special Tribunal for that. 2012, an agreement between the African Union and Senegal on the extraordinary African chambers. 2014 to 16, the Kosovo Specialist Chambers, and then the most recent one was the draft statute for the tribunal on the downing of MH17. In addition to these, what I would call conventional precedents, there are also the recent trend in people's tribunals, which are, of course, have no formal authority or powers, but these are light-footed, highly versatile, and may provide lessons in cost-effectiveness and streamlining of the work that might be required. Now, whilst the majority of these precedents dealt with a range of international crimes, and perhaps only two substantively address the crime of aggression, they all helpfully point to possible means and methods of creating a special tribunal. And that brings me to my second point. What might be some key best practices in terms of agreements or statutes from the available precedents? Well, I think there are three perhaps critical points here. The first is independence is key, as is application of relevant international conventions and norms. An international tribunal consisting of a majority of international prosecutors and judges significantly helps in this respect and would circumvent some of the problems related to immunity, legitimacy, and suggestions of selective justice, as Dapo has outlined, and the Sierra Leone Special Tribunal, which tried Charles Taylor, might be a helpful reference point there. Now, that of course, is quite different from an internationalized tribunal, which is a hybridized chamber within the Ukrainian court system. Now, there are some pros and cons of having a hybridized chamber, but of course there is still room for maneuver even if a court was to be part of the Ukrainian court system. The second point is we're all aware that costly, unwieldy and lengthy tribunals and courts rarely endear the international community. Now, I would argue that a special tribunal on aggression is significantly different in nature, scale and scope from the previous tribunals, such as, for instance, the Special Tribunal on Lebanon, which has come in for criticism for its cost, the length of time it's existed, and the fact that there were no perpetrators that were apprehended. The difference here is that there is also a significant possibility of a range of perpetrators being eventually apprehended in various circumstances which we could envisage. So I think here, a special tribunal in this respect may provide an opportunity for a very light-footed and bifurcated model, a staged approach in its creation with possibly an interim office, a preliminary prosecution team, and a part activation into an adjudicatory body with a small chamber if and only if alleged perpetrators are apprehended. And I understand my colleague Alex will address this point. This possibility, I think, allows us to worry a little bit less about the resources that may be diverted, as has been argued, from elsewhere, and that can be significantly mitigated. The third point here is that in respect of any possible special tribunal, cooperation, coordination, and co-investigation is critical, both in amassing the evidence and in investigating, apprehending, and prosecuting the alleged perpetrators. This is no doubt linked to having a credible and authoritative international tribunal with wide support, but also having significant powers either on its own initiative or derived, as Dapo has suggested, from national jurisdictions. This brings me to my third and final point. With whom exactly might Ukraine strike an agreement for a special tribunal? Dapo very helpfully has covered most of the options here. And I'd just add to say that, of course, that a special tribunal can be an agreement between the UN and Ukraine on recommendation, critically from the UN General Assembly. Now, that would provide significant legitimacy. The two perhaps relevant precedents here are a hybridized chamber within the Ukrainian court system, and the precedent for that would be the extraordinary chambers in the courts of Cambodia. And critically here, that was a body that was created on recommendation by the UN General Assembly. The alternative is a freestanding hybrid tribunal. That would be like the Special Court for Sierra Leone, and I understand, I might be mistaken, Dapo would correct me, that was actually set up by the UN Security Council, but not under Chapter 7. So again, it's another precedent that doesn't rely on a Chapter 7 authorization. A more realistic option, politically perhaps, is an agreement between the Ukraine and the EU, following, of course, the Kosovo precedent, and given that a joint investigative team under the EU auspices has already been set up, which ostensibly covers the crime of aggression, this would appear to be a possible natural progression. And an alternative, and increasingly a possible one, following loosely actually the African Union and Senegal precedent, would be a regional tribunal where an agreement could be formed between Ukraine and members of the Council of Europe. The PACE, the Parliamentary Assembly vote last week approving the creation of such a tribunal, obviously significantly augments this possibility. Perhaps the only critical shortcoming here is that it might require unanimity in order to create a special tribunal. And of course, we might have opposition in the form of two countries in particular, which would be Hungary and Serbia. The two alternatives here, as Dapo has suggested, is simply an agreement between an ad hoc group of states. That is a realistic possibility, including one that can be struck immediately with the possibility of future endorsement by others. And then perhaps the most unrealistic possibility, but it is foreseeable, is that an amendment to the Rome Statute is possible in 2025, although this is highly unlikely. My final point, I guess, is to say that we know that agreement with international organizations take time. Now, the very first step that could be already taken in respect of the work of a special tribunal is to actually begin in earnest with a coalition of the willing through an interim or preparatory office, as I understand Alex might discuss. And the sooner that work begins, the more likely the creation of a special tribunal becomes a matter, I believe, of inevitability as opposed to one of political expediency. Thank you very much.
Thank you. Thank you. Thank you very much. And let us continue on the options and why the special tribunal can be the best option. What is its importance for the development of international criminal law, and especially relationship, because we need also to define the jurisdiction with the crime of aggression as defined by the Rome Statute of International Criminal Court. And I am pleased also to introduce you to one more speaker who is online, Carrie McDougall. She is a senior lecturer at the University of Melbourne and former legal advisor to the Australian government, the author of the book, The Crime of Aggression under the Rome Statute of the International Criminal Court. And she also represented Australia in the Assembly of States Parties of the International Criminal Court. So, Carrie, please, the floor is yours.
Well, thank you very much. Let me begin by publicly expressing my solidarity with our Ukrainian colleagues, as well as my thanks to our Lithuanian hosts for the invitation to address this very important subject. Ministers, other distinguished participants, as I've written and spoken about elsewhere, I firmly believe that the only viable option for prosecuting the crimes of aggression committed on the territory of Ukraine is to establish a special international tribunal. I want to focus the very limited time I have explaining why, in my view, it's absolutely critical that the tribunal utilise the Rome Statute definition of the crime. Now, let's address the elephant in the room. The Rome Statute definition is not perfect. I devote many thousands of words to critiquing it in my book, but this is not a reason to abandon or tinker with it now. We should accept that this definition was the hard-won result of almost 65 years of negotiations and now represents agreed international law. I also think it's important to acknowledge that in order to secure the support of those states that are generally the greatest champions of international criminal justice, we'll need to ensure that the tribunal complements the ICC and is in no way seen as undermining that court. This means that the jurisdiction of the tribunal needs to be limited to crimes of aggression committed in Ukraine so as not to undermine the ongoing ICC investigation into other serious international crimes, and that we should make provision for cooperation between the tribunal and the ICC in relation to matters such as the sharing of evidence, but also that the definition of the crime must conform with the Rome Statute. Adoption of the Rome Statute definition will help ensure the tribunal's legitimacy by avoiding any suggestion that a crime has been tailor-made for the tribunal, and it will avoid any potential fragmentation of international criminal law. Now, while I've suggested that the Rome Statute definition isn't perfect, I would underline that I don't think that imperfections are something that will represent an impediment to the successful prosecution of crimes of aggression committed in Ukraine. Many of the criticisms that the Rome Statute definition attracts relate to ambiguity associated with the definition of the state act element of the crime, the act of aggression, so that its periphery is unclear. But these ambiguities will simply not come into play because Russia and Belarus's invasion of Ukraine represent a textbook example of the state act element of the crime, as does the 2014 annexation of Crimea, squarely meeting the agreed core definition of the crime. The definition of the crime of aggression under the Rome Statute restricts potential perpetrators to leaders. In technical terms, prosecution requires proof beyond a reasonable doubt of the planning, preparation, initiation, or execution by a person in a position effectively to exercise control over or to direct the political or military action of a state, of that state act of aggression. The definition very clearly captures persons of interest, such as Presidents Putin and Lukashenko. It captures influential members of their inner decision-making circles in relation to political and military matters, persons that might include, for example, Russian Foreign Minister Lavrov. In my assessment, it doesn't capture the yes men surrounding President Putin who have had no actual ability to influence the decision of whether or not Russia used military force, or the generals who are implementing the decision to wage an act of aggression. Now, I would emphasise that in my view, determining exactly who is captured by the definition is likely to rely on the provision of intelligence information. And for that reason, I do recommend that the Tribunal's statute include provisions on classified information in similar terms to the Rome Statute. I know our chair is interested in views on whether the definition could extend to members of the Russian Constitutional Court who upheld the legality of Russia's annexation of Crimea. And I'd have to say that in my view, such persons are excluded by the definition because they can't be said to have had a decisive say over Russia's political or military action. The last point I want to make is that commentators have in the past suggested that a broader range of perpetrators could be captured under customary international law on the basis of the Nuremberg and Tokyo precedents. And you might think that there are good reasons to adopt a broader definition of individual perpetrators in the current context. This argument really rests on the idea of a perpetrator being able to shape or influence, as distinct from direct or control, state policy, a test that was articulated in the Farben case. However, I think it's really important to note that the balance of post-war case law, including the Nuremberg and Tokyo judgments, are all inconsistent such that it's very difficult to identify any sort of agreed rule about who could be prosecuted. Even accepting that a broader range of perpetrators were prosecuted in Nuremberg and Tokyo than would be possible under the Rome Statute definition, I think there's real merit in the Rome Statute's approach. The crime of aggression is all about punishing those responsible for deciding to use illegal interstate armed force and deterring future acts. These goals will be best met by maintaining aggression's status as a special category of crime with a focus on genuine leaders. This will ensure that those who were ultimately responsible for the decision to invade Ukraine cannot shift blame to others. It will also maximise the potential for a prosecution to give other leaders pause for thought about future uses of unlawful armed force. Thank you very much.
Thank you, thank you, thank you very much. And I would like to continue also with a more detailed explanation on significance of a jurisdiction of possible the tribunal. I am pleased to pass the floor to Eka Tkeshelashvili, the head of the USAID flagship anti-corruption program in Ukraine, president of the Georgian Institute of Strategic Studies, and as well as the former Minister of Foreign Affairs and Vice Prime Minister of Georgia, as well as famous international lawyer, and who also specializes in public international law and international criminal law. Her topic is namely regional, political and legal implications of the tribunal, and as well as including ratione temporis issues, because actually we are a lot discussing how far should go the jurisdiction of the tribunal, because we all understood that that Ukraine is not the only direct victim of the Russian aggression, but it was some prehistory. And please, Eka, the floor is yours.
Thank you very much. I'll echo all of the participants of the panel to thank Lithuania as a country for everything they did do for Ukraine, but then specifically now here in the Ministry of Justice, Vice Minister of Justice, for convening us today. And as much as Philip mentioned it as well, just recalling back how this all started in terms of idea and then first steps, thinking of making impossible possible. And here we are already talking about the real stuff. And when it comes to the real stuff, not just the legalities of that, but then how that could be accompanied with the political steps when it comes to decision-making that could come into force in a short period of time, I would hope, with all of the efforts that we are putting together in this direction. We have very limited time, so that I'll concentrate perhaps on issues that I've picked up during the conversation and the panel, and then perhaps add to that. When we talk about a creation of the Special Tribunal, I think part of what needs to be understood by those who are well-intended naysayers so far, who say that whether or not creation of the tribunal will help or not ending of the war, let's say, if there's an inevitability of accountability for the higher-ups in the political spectrum in Russia, why would they even consider any peaceful talks, right? In this case, or whether or not if the tribunal is a paper tiger, does it make sense at all? Maybe it will bring more frustration to Ukrainian people that there will be tribunals, something will be happening, a lot of time will pass, but nothing will end up in the concrete result, so to say, impact that it could deliver. And then I would suggest the following. When it comes to the tribunal and importance of that for the second argument that I've just mentioned, for decades already in the region that I represent, colleagues from Ukraine represent, we have suffered from Russian, not only oppression, but military aggression a number of times. My own country, actually, in 2008, was the first country where Russia used force openly against another sovereign country without any repercussion as a result of that, and enjoyed the plausible deniability of what Russia actually did. What Russia did in 2008 was plain aggression against another sovereign country. which was not even labeled as such for different reasons, but then Russia maintained that possible deniability. Then, because of that, partially, not only, but that was the first time Russia tested the red line, so to say, successfully in Russians' view, and then what followed was annexation of Crimea, and then Donbas and Luhansk in terms of the de facto occupation of the territories, and then prolongation of the conflict. Again, very little as a repercussion for Russia. At least legality of annexation, as an annexation was recognized as such, and an acceptability of that, as much as territorial integrity of Georgia as well previously. But Russia basically paid very little price for that. So my message in this regard is that even the fact of credible tribunal delivering judgments on aggression vis-a-vis individuals that are culprits of that crime will be already sufficient, not fully, but satisfaction for so many of us in the region that Russia will cease to have any plausible deniability of what Russia is doing. And when we look about whether or not it is apparent that Russia is aggressing Ukraine now, we still live in our bubble of the Western world in one way or the other. Look at the voting of the UN General Assembly, subsequent second one, and then if anybody follows the media discourse in other parts of the world, it's not that straightforward. So when it comes to straightforward understanding that this is what it is, and this is aggression, plain, straightforward, and then even if that is established in a credible way, and even if culprits will not be apprehended anytime soon, this is still very important as a deliverable of that very important tribunal. Because that will have its own impact, I'm sure, globally, on the countries that still might have that illusion, if not political expediency for some now, to have this, doubtful understanding of what is Russia actually doing. Now, that's one very important factor. Politically speaking as well, it's very hard to imagine that if there will be judgments on Putin and then, his comrades or whatever they are called, how they will be active in a political scene, because there is a huge political component into that. It will be very hard to invite anybody in G20 meetings or anywhere else against whom you will have credible judgments that they are aggressors. So even if they will not be apprehended, put in prison or anything else, it is already punishment, and it's already justice that is served with that. Then the question related to financial aspects that the Minister Maluska raised today, hugely important. There is a lot of coordination right now in legal world, so to say, of the programs and then partners that are helping Ukraine now with war effort, and then legal field is a war effort in its own way as well, to see how tracing of Russian assets, seizure of Russian assets could happen. And then the sovereign immunity that has been mentioned as well. I mean, we don't have answers now, but this is a question to keep in mind. What is the relevance of all of that in that direction as well? Because Ukraine needs to be put back into life, not only just as a matter of rebuilding Ukraine. Ukraine needs to be reconstructed in the way that it will be a shiny example how much better, even more developed it will be, so that everybody in Russia who now supports the war effort sees where they are back to Soviet Union life, and then how international community can pick up support and resilience, and then, rebuild Ukraine in the way that it's everything contrary to what they hoped that they could achieve in this war effort. When it comes to the peace talks, I think this is important to realize as well that Russia has no intention to negotiate anything right now. Russia, and especially Putin, understands the language of war. And then if we take an analogy of the Second World War in that terms, and I'm not a military expert in this regard, but I have, unfortunately, quite a bit of expertise of dealing with Russians in my own life, it's the victory of Ukraine militarily that can define what will happen, not only for Ukraine and Russia, but for all of us sitting in this room, and then globally as well. What is happening in Ukraine is shaping the future of our children, grandchildren, and then for decades to come. So in this regard, nothing that could relate to the establishment of the tribunal could derelay any peaceful talks as of now. And if we take an analogy of what Philip mentioned of 1942 and then onwards, actually it could even help, because it could create incentive for some in the establishment in Russia to negotiate agreement for them, for being supportive of the defeat of Russia, if we put it in this way. So we can think of it as an enabler of the solution rather than an impediment in this regard. If we talk about sort of ratione temporis, I wanted more to, not to dwell too much, not to complicate the possibility of creation of the tribunal with what happened in my own country and then before, but rather to plea very strongly that the aggression did not begin on 24th of February. So if we speak about the beginning of the jurisdiction of the tribunal, it starts with the annexation of Crimea, clearly to me. Because even with the restrictions of the definition of the Rome Statute currently, annexation is there. And if we allow to have plausible deniability again, what happened in Crimea, as if there was real referendum, and if the green men, we are not actually a Russian military, so we are not doing justice to what happened. So beginning of the jurisdiction of the tribunal is starting clearly from the annexation of Crimea, and then that will be one of the biggest, strongest element of delivering justice to what Russia did to Ukraine, but we will feel vindicated as being Georgians and everybody else as well, who are still suffering from the occupation of Russia, by the way, in my own country, and you know, dangerous that others might feel, like in Moldova and elsewhere as well. And I would believe that even friends from Syria that we have contacts with will feel vindicated partially as well if justice is served in this case. Everybody who suffered from Russia will have that sense of vindication in many ways. And then ultimately, when it comes to the ratione personae, so to say, in this case, I would slightly disagree with limited understanding of who could fall into it, because Russia is a dictatorship, right? So that if you go too much into who can actually really influence to the decisive degree of decision-making processes, it will be very hard to establish who, apart from Putin, but I don't believe that it's a one-man show, but still could be culprits in it. We need to respect the constitution of Russia in this case. So who are the decision-making bodies? What is the role of the parliament? What is the role of the court? Who are enablers in the decision-making process that by definition have decisive role that they need to play? We cannot reward dictatorships by limiting the scope of who are responsible for aggression in this case. And I feel very, 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 very strong at my side on that, but I hope that there will be sort of a more broad definition of who are enablers and participants of aggression in this case, rather than very limited circle who could give a good escape road for those who are actually very much culprits of aggression against Ukraine now. Thank you.
Thank you. Thank you very much, Eka. Indeed, I fully agree with you that the classical principle of a division of powers is not applicable to Russia. Actually, I remember as the head of the Constitutional Court of the Russian Federation, he's one of the ideologists of this Russismo, Russian world, and in his books openly justified the annexation of Crimea and the decisions made by the threat of terrorism from Crimean Tatars and many other propagandic cliché. But of course, in future, it would be nice to have more detailed discussion on actually who is subject to the jurisdiction of a future tribunal, but now I would like to continue with the issues also of the jurisdiction, ratione temporis, maybe ratione personae as well a little bit, and what role can be played by the future tribunal for the victims of war. And I'm pleased to pass the floor to the next speaker, who is Oksana Senatorova, Director of the Research Center of Transitional Justice at Yaroslav Mudry National Law University, as well as founder and director of the NGO Center for International Humanitarian Law and Transitional Justice, and an expert of the International Council at Ukraine's Office of Prosecutor General. So please, the floor is yours.
Thank you very much. Madam Minister, Madam Deputy Minister, distinguished colleagues and friends, it's my honor to be here at this conference, and I also want to express my gratitude for people of Lithuania for opening your arms for Ukrainian people, for Ukrainians, and for standing with us in this struggle against Russian aggression for your solidarity with us. In my very brief presentation, I would like to stress the issue of a possible mission of the Special Tribunal, the role that it could play for the victims of this war. During the next discussion, I will be delighted to say a few words concerning the options and challenges of the Tribunal's ratione personae and ratione temporis jurisdiction, and some aspects of the possible composition of the court. I propose to begin by raising the question of how the international community and the Ukrainian people envisage this tribunal and its aims. As you know, the ICC has launched an investigation concerning war crimes, crimes against humanity, and possibly genocide. Ukraine and other countries will prosecute these crimes in the national jurisdictions of both Ukraine and other countries based on the universal principle. They are hopeful on the ECHR as well, but will the victims of this war be satisfied when the ICC brings a few people to justice after a rather considerable period? How many people will be directly compensated through international and domestic trials? We all know the answer to these questions. Let me remind you that victims of the aggressive war are not only those who have suffered war crimes and other international crimes, though there are thousands of them in Ukraine. Millions of Ukrainians experienced so-called self-evident consequences of armed conflicts, such as cannonades, shelling, the necessity to become refugees and IDPs, and the legitimate, according to the IHL, attacks that caused loss of life, legitimate damage to civilian objects and infrastructure. They will not be considered victims of serious violations of human rights in the IHL, and thus could not hope for reparations in ICC or national jurisdictions. But they are victims of aggression, of the crime of aggression, those who have never been directly compensated after the previous world wars, as far as there was only state-to-state reparations proceedings. There are only some precedents of ad hoc mechanisms of direct restitutions to the victims of aggression. I mean, the United Nations Compensation Commission established to determine and dispense reparations after Iraq's invasion of Kuwait in 1990. The Ethiopia-Eritrea Commission criticized, frankly speaking, but take into consideration that those mechanisms were created after the end of hostilities, and the first one I mentioned was created by the United Nations Security Council decision. Nowadays, the ICC has a mechanism of reparations for the crime of aggression. Still, it cannot be activated because of the absence of the ratione materiae jurisdiction in our case. Actually, it was never activated for the crime of aggression, and I'm not sure it will be triggered in the near future. So this tribunal will present, can make an input for realization of the idea of reparations to the victims of aggression. As for the ECHR, European Court of Human Rights, it has only limited opportunity to compensate the negative results of Russian aggression. It is possibly only for the gross violations of human rights, such as the crimes against humanity, but not for legitimate attacks because of IHL lex specialis. The only way to bring justice to the millions of Ukrainians whose lives have been ruined in this war is to prescribe a special mechanism for reparations to the victims inside the tribunal. In my view, the victim-centered approach should become one of the main goals of this tribunal. Another important goal is to provide the credible deterrence and criminalization of the crime, not criminalization, deterrence of the crime of aggression. Over the past decades of multiple Russian Federation occupations of the territories of the neighboring countries, this violation of Jus Cogens rules was tolerated by the international community. I echo to your words in this regard. Hobbled United Nations Security Council, narrow jurisdictions of ICJ and ICC, and the other big countries' frustrating precedents of the absence of liability for illegal use of force. They ensured the Russian leaders would not be held accountable for their acts of aggression. And as Benjamin Ferencz said, that aggression is a breeding ground for another international crimes. Thus, prosecuting aggression, we prevent them also for future generations. I don't know whether I have time for opening the challenges, but I would like to stress only several of them, several questions. The modes of realization of this mechanism is also the issue for discussion. We can use the model of ICC, overcoming its imperfections and gaps, taking into account the experience of ad hoc mechanisms and national mechanisms of reparation during transitional justice proceedings. The open issue, the open question is the circle of victims of aggression here. Whether it will be only individuals or only the legal entities, communities, whether they are only Ukrainian citizens or representatives of other countries as well. Should combatants be included, because the use in Belo doesn't work here, or only protected by IHL persons? Should Russian citizens who suffer because of their fight against this aggression be included? Lots of questions to answer. What source of financing should be chosen for the reparative mechanism? All of us discussing today this issue. Should it be only the assets of criminals, arrested property of the Russian Federation? As you know, the crime of aggression is an act of a state. Donations, maybe from international organizations, democratic states, and private funds. Everything mentioned could be taken into account. To my mind, the more sources, the better. But of course, it is an open field for discussion. Touching the jurisdictional issues, I should kindly remind you that there are several challenges concerning the Republic of Belarus and its de facto leader. Of course, Belarus violated at least Article 3F of the resolution 3314, the definition of aggression. But we must take into consideration that the EU and other countries consider Lukashenko legitimate, which may mean he doesn't possess the immunity ratio persona. Of course, it is not about the prosecuting him in domestic jurisdiction, but maybe it can play the role in the international tribunal. We also have to discuss the opinion of Belarusian international lawyers who consider that Belarus was occupied after these elections, illegal elections, and maybe it brings some other angles to this discussion. And of course, I support ECHA that the beginning of the temporal jurisdiction starts in the late February of 2014, at least the 20th of the February, with the invasion of Russian Federation to Crimea. And of course, we have to consider the qualification of this conflict. It is definitely the international armed conflict, and I want to pay attention that there are no separate conflicts. The Crimean conflicts, the Donbass conflicts, it is only one conflict which started with the invasion and then continued in proxy character in Donbass region. And of course, it was continued with this hot phase of hostilities after the 24th of February. The last one, but not the least, the judges, the composition of this court. I suppose that they should not be the representatives of states, if we are talking about the multilateral treaty, for example, but they have to act in their personal capacity. And I, of course, want to pay attention and to discuss the opportunity to include judges from the Russian Federation and Belarus, those who are impartial, non-governmental experts representing the democratic parts of the peoples of those countries. I know some of them. I realize that this proposition would launch a whole discussion, but we should recognize that the value it brings to the principle of impartiality and impartiality of this impartial role of this tribunal. Thank you for your attention.
Thank you, Oksana, very much. And now let's go to the more detailed issues such as investigation and prosecution, and I don't know, what is required to prove the crime of aggression, and what is the central challenge of the investigation. I am pleased to pass the floor to Alex Witting, who worked at 3 different international tribunals and currently is the deputy prosecutor of the Kosovo Specialist Prosecutor's Office in The Hague, and also visiting professor of practice at Harvard Law School. So please, the floor is yours.
Thank you, and I want to join in the others in thanking the organizers, the Ministry of Justice of Lithuania, the Justice Hub, and of course all the participants, all of you who are here today, who are committed to thinking seriously about accountability. I will speak very much from the perspective of a prosecutor. As you heard, I have worked in 3 different international tribunals in The Hague. I'm now at the Kosovo Tribunal. I was also a federal prosecutor in the United States. And I'll draw on that experience to make a few remarks about the idea here that we're talking about. And I want to talk about 3 points. The first is, what are the challenges facing prosecutors? The second is, what would a court look like? And the third is next steps. So with respect to challenges facing prosecutors, you've heard from a number of previous speakers what the elements of the crime are, and it's that there was an act of aggression, manifest violation of the UN Charter, that the perpetrator played a principal role in it, in initiating, planning, executing the act of aggression, and then fourth, finally, that the perpetrator had effective control over military or political acts of the state. And I will echo what Gordon Brown said this morning and was echoed by Philippe Sands this afternoon, that the path, with those elements in mind and the evidence that is available to everybody now and what we can see with our own eyes, the path to an indictment of Mr. Putin is pretty straightforward. And it is particularly straightforward in comparison to imagining a future indictment of Mr. Putin and the leadership for war crimes, crimes against humanity that are being committed in Ukraine. There are intensive investigations going on right now by the excellent investigators at the International Criminal Court and of course investigators in Ukraine to try to show that responsibility. But that is, I can tell you from experience, that is hard, painstaking, long work. It's one thing to sit here and think, well, of course they're responsible. I can tell you it's something completely different to prove that in a courtroom with real evidence beyond a reasonable doubt, which is the criminal law standard. The evidence required to prove the leaders responsible for those crimes usually is derived on pattern, establishing a pattern of crimes, and then also developing linkage evidence through witnesses, communications. That's hard evidence to get and to prove. And the investigation, I would expect, would take some time, be painstaking, and then the proof in court would be also long and painstaking. In comparison, an aggression case against Mr. Putin would be relatively straightforward and more solidly based in terms of evidence. The leadership case for war crimes and crimes against humanity will not only be difficult, but will always be contentious. I think the principal challenge for the prosecutors on an aggression case will be not Mr. Putin, but who else? The people around, and you just saw that. That was just nicely illustrated between Kerry and Eka, talking about, well, how do you make the decision about who else is going to be in that circle? And I think that would be the hard work that the prosecutors would face, is developing the evidence, because it's not enough who has de jure power. You'd have to prove who had actual power to affect the decision. The second point I wanted to talk about is, what would this court look like? And here I really want to very directly address the issue about resources, because that is floating around. And just to give you the punchline, I don't think that the concern about resources should be a serious impediment to constructing this tribunal. I think that given the very specific task that this tribunal would face and the kind of evidence that is available, it could be a relatively and objectively small court. I think that the office of the prosecutor could be not much bigger than this panel, honestly. Seriously, 10 to 20 people, really 10 to 20 people in the office of the prosecutor, if you got the right people. If you had prosecutors, you'd collect some prosecutors, investigators, analysts, some cooperation advisors, but a core group of 10 to 20 people in the prosecutor's office, which is much smaller than any other international prosecutor's office that exists. And then on the judicial side, you would follow the model of the Kosovo court and have a roster of judges, but only bring in judges and pay them when they had work to do. So you would bring in a judge to confirm the indictment, but you'd only bring in other judges if there were people who were actually arrested. And so I think that this could be done, honestly, for very little money. We were talking about whether that would be the equivalent of 1 or 2 tanks to pay for the tribunal. But really, this is inexpensive justice. And then the third point I wanted to touch on is, what are the next steps from here? And Arif anticipated this point. We heard this morning from the Ukrainian Minister of Foreign Affairs, Mr. Kuleba. He said at the end of his remarks, he demanded concrete and swift action. Those were his words, concrete and swift action. And I'm encouraged by this, by how much has happened already on this idea and what's happening here today, that this idea will be achieved. But a concrete and swift action could be to set up an interim prosecutor's office to begin already to collect evidence. And I think there would be 3 advantages to doing that, 3 important reasons to doing that. The first would be that there is a certain amount of startup time that is required for setting up a prosecutor's office, finding the right people, having a place set up, and protocols and so forth. And that time could already be invested now if you set up an interim office. Secondly, I think that taking concrete steps would help make this a reality. If this started, we're here talking and there are lots of ideas and there are lots of challenges, and the main challenge is how to translate that into reality. Taking actual steps to have people start working on this would help accomplish that. And then the third thing is that, of course, it's always an advantage for prosecutors, and again, I'm thinking as a prosecutor, always an advantage for prosecutors to get in early and to start collecting the information, preserving it. I don't think it's going anywhere, but that work should start right away. So if we want to heed the words of the minister, Mr. Kuleba, concrete and swift action, that's what I would do. Thank you.
Thank you very much. And now the last speaker in our panel, Anton Kornevich, an associate professor of international law in the Institute of International Relations of Taras Shevchenko National University of Kiev, also an agent of Ukraine before the International Court of Justice in the allegations of genocide case. Before that, he also served as permanent representative of the President of Ukraine in the Autonomous Republic of Crimea, and his field of expertise involve public international law, international humanitarian law, and international criminal law. So please, the floor is yours. You're on the impact and expectations of Ukraine from this future tribunal. And before giving you a floor, I would like to say that I abuse a little bit my powers of moderator. Let's extend the session up to 20 minutes.
Thank you so much, Professor. Dear colleagues, first of all, of course, I would like to start with huge thank you to the whole Republic of Lithuania for all the support we see for all these 8 years of Russian aggression, and of course for the government and the Ministry of Justice and for the Law and Democracy Center Justice Hub for holding this conference. This is the first big conference dealing with specific issue of this special tribunal on the crime of aggression against Ukraine, and I'm sure that this is an important event, important moment, which will bring us closer to our final goal, to the establishment of the tribunal and its prosperous and effective work. Of course, it's a big pleasure, and it's very important and to be here present with such a distinguished panelists and to share some thoughts and ideas as a Ukrainian lawyer concerning Ukrainian perspectives. Well, for Ukrainian lawyers who work now in the field of international criminal law, international humanitarian law, in general international law, I think that this is some kind of a duty, and this is more than a job. It's actually not a job of coming to the office and working there from 8 till 6 or whatever. This is something what you need to do. You need to do whatever you can in order to make all this happen. And I wanted to start with the issue of importance of the establishment of the tribunal for Ukrainian people. And I want to mention that it is very important for us all to realize that for Ukrainians, for our nation, for our people, it is very important to have justice and to bring perpetrators of this war of aggression to responsibility. It is not only about the cells in the prison, but this is about indictments, this is about arrest warrants. And Ukrainians now really much feel that we are making history. Like our armed forces, we are beating the Russian armed forces, I mean, who pretend to be strongest, powerful, but I mean, in many places you see the story, how the story goes. So this is history making, and of course our main heroes are our Ukrainian soldiers and officers, our armed forces. They are making an unbelievable job. But I think that understanding these historical moments for Ukrainian people, it is very important that the justice also happens. And this analogy with Nuremberg and Tokyo, I mean, of course, pay particular attention to Yugoslavia, of course, in the 1990s, but this idea that the biggest war in Europe happened in 1945, and after that, this is the biggest war of aggression, and the prompt and appropriate legal answers were the establishment of Nuremberg and Tokyo Tribunal, and the establishment of the Special Tribunal for the crime of aggression against Ukraine is really seen by our nation, by our people, as a proper and appropriate legal result. So that is why I'm sure that Ukrainian civil society, Ukrainian experts, ordinary citizens will really very much be in favor and of the establishment of the special tribunal. It is also understood throughout Ukrainian legal community and in civil society that for bringing perpetrators of the crime of aggression to justice, we need the establishment of the special tribunal. Because everybody understands that with due respect to the ICC shall do its job with the war crimes, crimes of aggression, alleged crime of genocide. With all due respect to national investigations and national courts proceedings, they are not operational, yes, because ICC doesn't have jurisdiction over this crime in this particular case, and Ukrainian national courts will have to deal with immunities, with personal immunities of the highest political ranks of the Russian Federation. So of course, this is also why the special tribunal is so important for us now. It is also, I think, that this panel is a brilliant example why this tribunal is important for international legal society, for intellectuals, for international lawyers. And I think that all these brilliant colleagues have gathered together a lot of things right now, and we have a relevant background worked on this expert level to move further to the governmental track. I think that now the moment has come with these resolutions of the Parliamentary Assembly of the Council of Europe, with this Vilnius conference, with these esteemed colleagues participating in it, to move further to the governmental track. And I'm sure that these governmental official consultations will start rather soon. It is also important to realize that the establishment of the tribunal is supported by the Ukrainian state authorities, in particular by Mr. President Volodymyr Zelensky. He publicly supports everything which deals with legal responsibility of the perpetrators of all the crimes which were committed and which are still committed by the Russians in Ukraine, and he himself talked about the tribunal concerning the crime of aggression, and the management of the office of the president also publicly on press briefings for Ukrainian media in interviews talk about the importance of the establishment of these tribunals. You heard today the brilliant intervention by Mr. Dmytro Kuleba, Minister of Foreign Affairs of Ukraine, who also is a big proponent of the establishment of the tribunal, and I'm sure that the ministry will be very effective in doing the job, in making this official governmental track happen. Concerning the civil society support in Ukraine, we also cooperate with different Ukrainian human rights NGOs, activists who work throughout all these 8 years in relation to gathering the evidence of alleged war crimes, crimes against humanity, now the alleged crime of genocide. And we may be pretty much sure that the idea of the establishment of the special tribunal and understanding that there are really no alternatives to it, if we really want to talk about legal responsibility, individual criminal responsibility of perpetrators for commission of the crime of aggression, so that really there are no real alternatives to this. And maybe to sum up, to wrap up, concerning the expectations of Ukraine from the tribunal, of course, the main expectation is to bring individuals to responsibility for committing the crime of aggression against Ukraine. And again, I will echo the thing which I just said, that responsibility is not only about the prison. This is about indictment. This is about arrest warrant. This is about non-participating in normal political life of the world, of the region, of the country. So this is really very much important. I think that for Ukraine, and for Ukrainian people now, it is very important that this aggression against our state, it cannot be left without the proper legal response. Because Ukrainians believe in international law, I'm sure of that, and they understand that international law is about protection of those whose rights and interests are being violated, in our case by the Russian Federation. So I'm sure that this understanding that this war of aggression should not be left without the reaction. The world cannot be silent. This is very important. Because whenever, we have even such a poem in Ukraine by one of our poets. It has a line there, like, when Ukraine was raped by Russia, the Europe was silent. It's not about our time, it's about the beginning of the 20th century, but Europe was silent. And Europe and the world should not be silent anymore. And of course, concerning the ratione temporis, as I served as the president's representative for Crimea for almost 3 years, of course, for myself, it is obvious that the crime of aggression, ratione temporis jurisdiction, shall start in the end of February 2014. Again, this is important for the nation, and this is something what our people understand in general, and it doesn't need to be clarified to them. And one last point is that we see the very beautiful sunflowers here on these tables. Sunflower is a symbol, unfortunately, of a big tragedy of the Battle of Ilovaisk in the end of August 2014, when Ukrainian armed forces got a lot of casualties it was one of the biggest tragedies before 24th of February 2022. The sunflowers in the field near the city of Ilovaisk in Donetsk Oblast, Donetsk region. But after 24th of February, we have Bucha, we have Irpin, we have Hostomel, we have Mariupol. We don't know what is happening there. And we need to do all our best in order to get these perpetrators responsible for all these crimes and for the crime which gave rise to all the other crimes, the crime of aggression. I thank you.
Thank you, Anton. Thank you very much. And now it's time for questions and answers, but again, I'm a little bit abusing, because I can mention at least 3 questions I usually receive from the audience and from public here in Lithuania regarding the Special Tribunal. First of all, of course, it's the question which we haven't touched here, but maybe a few words about that, the possibility of trying in absentia. Because who knows, maybe, it's also possible way of development. Next 2 questions, they are, of course, much broader, but again, it's possible to say a few words about that. Regarding ratione temporis, really, I feel that the people expect that the Special Tribunal would somehow, I don't know, involve previous acts of aggression, even before the Crimean annexation. I mean, again, Georgia, maybe, I don't know, Moldova, who knows, but anyway, at least I feel such expectations related with, because it's the general feeling of justice and the general need to condemn the dictatorship in Russia. And the last, because I'm even obliged to ask you, because Justice Hub was established, first of all, as NGO devoted to Belarus. What about Belarus, really? Not about its involvement in the aggression, but how do you think maybe the Special Tribunal can serve as the precedent for the future tribunal, also for the crimes against humanity, because it's my firm belief that this is crimes against humanity, also committed by the Belarus dictator against his own people, or it's also somehow possible to involve. Of course, there are too much expectations, but anyway, in a few words, maybe starting with Felipe.
Thank you. Gosh, what an incredible privilege listening to this group. I have learned and thought a lot. Very briefly, in absentia, this is a very culturally specific issue, and although I am a dual French-British national, on this issue I'm afraid I take the Anglo-Saxon approach, the common law approach. Trials in absentia are really problematic for common lawyers for lots of reasons, and the one experience that we've got of it, the Special Tribunal for Lebanon, frankly, has not been a happy experience. So my instinct, but of course I'm open to all argument, is to steer away from that issue. I'm really struck by what Anton and actually a couple of other colleagues said, is that the mere issuance of the power to investigate, an indictment, an arrest warrant has consequences. We know that has consequences. So the need to have someone actually appear, of course, in an ideal world, is what one should be aiming for, but that isn't the marker of success or effectiveness, in my view. Ratione temporis, I mean, it seems pretty clear to me that you cannot exclude what happened in 2014. It's part of a continuum. But of course, you've raised the question, Mr. Chair, and sitting next to our friend from Georgia, and I was counsel for Georgia in 2008 in the case before the International Court of Justice. It is to this day, at the time I described it as the worst judgment I had ever received from the International Court of Justice on a frankly ridiculous technicality, ruling that the court didn't have jurisdiction. And I think the court really needs to take account of its responsibilities for sending a very clear signal to Russia back in 2008 that you can do this and get away with it. And I suspect that the far-reaching nature of the provisional measures order that Anton so successfully obtained with his very distinguished colleagues recently probably in some way has a connection with the court's failure in that early case. So I think, to cut to the chase, there is a real issue about how far back you go, and I suspect people in Georgia would feel pretty aggrieved in a sense that that issue is kept out. And separately, I sat for the first 2 days of this week in a hearing in an investor-state arbitration case as an arbitrator in which the respondent state is Moldova. And in the coffee breaks, one talked, as one could appropriately. As an arbitrator, it's delicate, but with the colleagues who had come from Moldova. And I am acutely conscious of what is happening in that country right now and the very real anxieties. And as you said, Oksana, it is already partly an occupied country de facto. So I think there's a real issue to address. And finally, in relation to Belarus, I think it has to stay, this special tribunal, focused on the crime of aggression. I want to underscore, I think, what Carrie said, which is that the ICC, the Ukrainian courts, maybe the Polish and German and other courts will deal with war crimes, crimes against humanity, and if it rises to that issue, genocide. But this institution must work very closely with the International Criminal Court. To my mind, and I strongly support the Council of Europe resolution, but it seems to me that if there's going to be a special tribunal, there's really only one place that it can be, and that is The Hague. It has to be in The Hague, and it has to be working alongside with, complementarily to the ICC. Can I just say one final point, just listening to everyone? Going back to that moment when Alice Fishburne got in touch with me from the Financial Times, would I do an op-ed? One of the inspirations for me at this moment is I go back to 1945, and I go back to these two guys who spent the formative years of their lives as students in the city of Lviv, Hersch Lauterpacht and Raphael Lemkin. They were deeply and intimately connected with that city. 25 years later, they found themselves in the summer of 1945 cooperating with Robert Jackson and various other people. They did not know at that point about the fate of their families. It was silence, as it is for many people now in relation to Ukraine. They could have gone into a corner, curled up, and wept, but they didn't. They had ideas. They put those ideas into practice. They worked with the prosecutors, and they then prosecuted without knowing that the man they were prosecuting, Hans Frank, was the person who was indicted for the murder of their entire families. And that, for me, has been an inspiring thought. This is a most difficult time for our Ukrainian friends. We could all just say, oh, it's not important, oh, yes, there are other courts and tribunals dealing with it. But let's get to the heart of this issue. There are terrible crimes occurring in Ukraine, but there is only one crime that gets you to the top table. For countries to say, oh, it's going to cost half a tank or 2 tanks or whatever, and we're not willing to pay that, frankly, would be outrageous. And this is a special moment in European history, and we have to be up to the challenge of doing it. And being up to the challenge, and I'm going to come out here on the side of Eka rather than Carrie, it's not just about the narrow 2 or 3 people. It's about an inner circle, and in particular, the finances. Who is funding this work? They are part of the crime of aggression. So yes, let's take the ICC definition, but let's fine-tune it to make sure that we don't let other people off the hook. This is a vital moment, and I know that already I've been privileged to work with Ukraine and 5 countries informally in drafting. We've prepared a draft agreement, we've prepared a draft statute, that all exists. I really encourage those of you who are from other countries to say, you know what, this is the right thing to do now, and to step up to the plate and join this initiative. It's really necessary.
Thank you, Philip. And now Eka is raising your hand.
Very sort of on indictments, and then I guess in my own intervention I jumped into the judgments. I might dream of it too much, I guess, but then yes, I agree that indictments and then arrest warrants in that sense is more what I meant in the case of in absentia situations. But what would be important, and this is not something that lawyers frequently think about it when it comes to preparing materials and then indictments and imprisonment, sort of the arrest warrants, communication element of that. So if there will be only indictments and arrest warrants for some time, it will be very important to make them public in the right way, without having trials, to have, you know, almost semi-trials, so to say, at least explanation what goes into indictment, what goes into arrest warrant, and then presenting evidences in that way, at least in this way, not fully as you do in the trials, but then giving that information to the public. So it's not just we were sitting somewhere there and then we found evidence for this and that, but explaining that, so that that gravity of the definition of what has happened and then what is the level of responsibility of any given, as an alleged one, at least, of individual, I think that would be important. So a bit creative way of looking into that could be important. And when it comes to Georgian position in that sense, I just want to clarify that indeed, ratione temporis, I mean, we would definitely see that that should include aggression against Georgia, but if it becomes an impediment in any way for the creation of the tribunal for the case of Ukraine, we would rather see the tribunal taking place and then be effective and set, because that will be some kind of indication in an indirect way for the past crimes as well for those who suffered. So it's important to move now, to be concrete and swift, and if anything complicates issues even further, then we were ready, at least I am personally, not to complicate it further. But when it comes to including or not annexation of Crimea, I would humbly submit that that is a very firm criteria in my perception, that it cannot be from the 24th of February of 2022, but then it needs to go well to 2014 for sure.
Thank you very much. Nobody else? So maybe only one question. No. Yeah, yes, please, from the audience.
Thank you very much. My name is Alan Kessel. I'm the legal advisor of Canada, and delighted to be here and also to listen to such eminent jurists and professors and the like, and especially at a very difficult time. But I do want to say something, and Philippe, I may want to take exception just for one thing you said, which was, which left the impression that some of us were not as engaged. And I want to say on behalf of not only Canada, which is very, very engaged in this particular issue, but many other countries which are our allies, spend 24/7 since this began in February dealing with this particular issue, that we are looking at every conceivable way to ensure that justice is arrived at, whether it be on the battlefield or whether it be on the battlefield of law. We're very much aware that the law is not going to be the determinative immediately, and therefore we are doing multitasking. But I do want to say to those of you who are analyzing and potentially thinking that we're just voyeurs on this subject, we are not. What I do think you need to do is get your story out in a way that you've done it today, and you need to be speaking to some of the other people who are out there. You do know that there are some serious legal questions related to the concept of aggression that have been around since the creation of the International Criminal Court. And I think a job that you need to do is try and figure out how do you allay some of those concerns. Some of you will be aware of the discussions that we had in the basement of the UN 2 years ago as we dealt with this issue. It was not pretty. But the reality is that it's still out there, and some of the major concerns related to it are remaining, and we would like to get over some of those. That's why we are supporting the International Court of Justice, and we're right there with the team, with the legal team. We're supporting the ICC, and we were there with the 43 others. We are supporting the Moscow mechanism, the OSCE. We're supporting the Human Rights Council and the agreement that's going to come out. And we're supporting every other report that is coming out on this in order to raise and continue the pressure that we need to. And, you know, we are with you in so many ways, certainly I have a full team who wants you to know that every single day we're working on this issue, and I can say probably for other of our allied governments that are here that this is not unique just to us. So take that message back with you as well, and we're certainly open to discussing further these issues with you. Thanks very much.
Thank you very much. And please.
Just,
please.
Alan, dear Alan, before you could please sit before you go. I think you understood that my words were not directed in particular to Canada. I've had a number of conversations with senior Canadians, and I am totally aware. I wasn't here, and I apologize that I wasn't here this morning, but there is an elephant in the room here, and let's address it. I know I was focusing on 3 members, permanent members of the Security Council. That's who I have in mind. And I know that there are elements within the permanent membership of the Security Council, Britain, France, the United States, who are thinking about this very seriously, and in some cases with a very open mind. Here is the issue. We know that, for example, recently, the British Foreign Secretary Liz Truss has said, basically, she supports the idea. And she's raised the issue that Alex raised, finance, resources, diverting stuff away from the ICC, which, frankly, is not a reason. We know what the real reason is. If the international community, or a part of it, creates, in the coming period, a special criminal tribunal for the crime of aggression in respect of 1 permanent member today, why could they not do it in relation to another permanent member tomorrow? And of course, there are other elephants in the room in relation to certain past military actions that I should best probably not name. That issue is going to have to be addressed at a political level. I've had private conversations with representatives of 2 of those 3 countries. The issue is, how do you ring-fence this decision? How do you create a basis for establishing a special criminal tribunal which allows you to really limit the risk of seepage? Because if you don't limit that risk of seepage and the creating of a precedent that could easily then be used in another context, and I'm sure we're on the same page, Alan, on this issue, there's no way you're going to persuade countries like Britain, France, and the United States to actively get involved. They haven't opposed it, and they're not going to oppose it. That's very clear to me. But I want them on board. I think they would bring a huge amount. And I'm open, Alan, privately, less privately, with anyone, to think through what is the delivery mechanism for creating this institution which brings maximum comfort, that it truly is only in the most egregious situations, such as this, that you open the door to such an approach. And I'm really grateful to you for your intervention, because it allows this issue to come out on the table. But having just been in Ottawa only a week ago and been so generously received, I can assure you Canada was not the subject of what you very rightly picked up.
Thank you. Thank you very much. And, I would like to thank and express our gratitude to all the panelists in this panel. And I have somehow to finish this conference in a few minutes, so my closing remarks would not take a long time. Of course, maybe it's not my own feeling, but actually I think we succeeded in achieving the main purpose. It's to gather it's the first conference, I guess, on the topic, so I believe there will be continuation somewhere in some places, but still our main purpose was to gather all of you who, first of all, signed the statement and the declaration, who also shares this idea, into one place after such a long pandemic time. And of course, to a certain extent, what happened for me, it's also sort of fantastic, because when we started to speak on this idea, especially with Mykola, I can frankly acknowledge that it was, you know, at that time I didn't expect that you really would be able to come, because nobody actually knew what would be the development of the situation. So we're really happy, first of all, to have all of you here, and it is a good opportunity again to restore the networks that existed before, to create the new networks, and also to promote the idea of the justice that should be accomplished in this particular case, especially that actually all our civilization is at stake. So instead of making any conclusions, I just would like to ask you to support the text which is distributed here as the Vilnius communique. We would like to be mentioned somewhere as the place where the first conference was held, and I can read only maybe the final point of this communique, that the participants of the conference reiterate the importance for our and future generations of ending impunity for the core international crime of aggression against Ukraine, express support for all international and national legal efforts that have been undertaken in prosecuting individuals responsible for war crimes and crimes against humanity being committed in Ukraine, as well as for the necessity of finding an effective mechanism allowing to prosecute individuals responsible for the crime of aggression. Welcome the recent proposal made by the Parliamentary Assembly of the Council of Europe, encouraging urgently to set up an ad hoc criminal tribunal for investigation and prosecution of the crime of aggression committed by the political and military leadership of the Russian Federation, call upon states to continue discussions on the possibility of ad hoc international criminal tribunal for the crime of aggression against Ukraine, and consolidate political will with a view of implementing the proposal made by the Parliamentary Assembly of the Council of Europe, and finally encourages creation, it's the most important, I think, for our conference, of international network of lawyers and academics to elaborate and advocate the idea of the ad hoc international tribunal for the crime of aggression against Ukraine. I hope, you know, of course, this text will be still subject to language editing, but I think it reflects the main ideas that we can share, and I'm really would be thankful for your endorsement of this text, which also will be published. And finally, of course, I would like, on behalf of organizers and as minister, I would like to thank all the panelists, also who took part in the previous sessions. I would like to thank the distinguished audience for patience, maybe, and also for your interest in this important topic. And I would like also to thank all the technical, organizational team for the organization of the conference. Indeed, it was, to a certain extent, a challenge to organize the conference almost in a month or so. It's not usual, let's say, for organizing international conferences. And also, I would like to thank our translators for a very important job to deliver messages and to making bridges between people who don't understand each other directly. So thank you all, and let me express our hope that this is the beginning of a huge job, actually, and we believe in success, and we are happy that we, let's say, made maybe the first small but significant step. And we hope that this initiative will be continued, will be promoted. We still need to persuade a lot of maybe skeptics, but for the sake of our future, we are obliged to do that. So thank you all.